right?
Okay.
All this close in order.
Okay. Oops. Okay. Hi, everybody. Welcome. This is the Sunshine Ordinance Task Force meeting December 4th. I'm calling it to order. Start with roll call. I was going to say Miss Osbury, but it's Mr. Young. Can we have a roll call, please?
Yes, on the call the roll. Member Nee? Here. Nee present. Member Washburn?
Here.
Washburn present. Member Pilpil?
Present.
Pilpil present. Member Sims?
Present.
Sims present. Member David?
Present.
David present. Member Highland?
Present.
Highland present. Member Oka?
Present.
Oka present. Vice Chair Fisher?
Present.
Fisher present. Chair Grant?
Present.
Grant present. We have a quorum.
Great. Can we call the next item on the agenda, please? Oh, I'm sorry. We want to do agenda changes. So let's go through this. Item number 3, file number 12059. The actual complaint has been resolved, and the complainant withdrew his complaint. So we don't have to hear that one. Item number 6, file number 13030, complainant filed by Charles Pitts. He requested a continuance after the deadline, so that's why it's still on here. And I don't know if anyone is here from the Community Housing Partnership.
Or HSA.
But that's who his thing is against. So is anyone here representing the other side? No? Okay, great. So he requested continuance on item number 6. And that's it. If anyone else has any other agenda changes or anything?
Item number 8, we received a continuous request approximately 1 hour ago.
From Barry Tarantino, item file number 13033. He's requesting continuance until the January meeting. Is there a representative from MTA?
Yes.
Okay, so are you, he's not here. Can you come to the, thank you.
Hi, my name's Roberta Boomer. I'm with the MTA.
Okay.
While I would have preferred to have heard this today, I will bow to the will of the Commission. However, I do want to make a comment about this even appearing on the agenda after we did provide our response. An email was sent to Mr. Toronto that informed him that he had 5 days to respond, and if they didn't hear from him, they would consider the matter closed. No, he did not respond, not only within the 5 days, but at all. So I'm a bit confused. If this was then supposed to be closed, how did it get on the agenda? And I also want to express my appreciation to your clerk, Mr. Young, for calling me an hour before the meeting to say plans have changed. So that's all I have to say. It's just hard when the game rules keep changing on us. So
Yeah, exactly. Okay.
Thank you.
Thank you. So Mr. Young, so in his email, he's saying that he received, so you have to refresh my memory. So we, with what we had agreed before for him, do you remember? Okay, so he received this notice. He did not respond at all? The
We do
complaint.
not have a response in the file.
So we didn't get anything from him, and then this is the first thing you got an hour ago?
Yes.
Okay. Remember Todd Pilpel? You go. I saw you.
Todd Pilpel?
No, I was saying, remember Todd, I saw you, and then I saw you. So that's why. No, remember Todd.
Chair Grant, I was wondering, it seems like it looks like we have an infant in the audience, and I was just wondering what case that they're here for, and if it might be possible for us to take that case out of order in order to help the family get the child home in a reasonable time frame.
What case is it?
7.
Madam Chair?
Yeah, I just want to see what it was first, yes.
Yeah,
It's actually,
unless there's an emergency situation, I have problems with taking matters out of order.
yeah, and actually, the way, because item number 3 is now gone, you actually are going to be heard sooner, like, it's the second case, yeah, so it's the second case, okay? Do you have a question? Who has a question?
No, she said that's fine.
Oh, okay, thank you.
Well, that's fine that Member Nee has an objection to that, but I still would like to, I'd like to put it to a vote to the board, because, as you know, families, it's tough to raise a family in San Francisco, let alone sit through a Sunshine Ordinance Task Force meeting. And so I think that this is a special situation, and I don't think it's a huge accommodation. It's not putting anyone else out in a big way to get a 7-month, 8-month-old infant home in, a half an hour as opposed to 2 hours. So I'd make a motion to move item 7 to be the first issue the first item on the agenda.
Do I have a second?
I'll second it.
Discussion.
Member Pelpel?
I had some other comments on agenda changes, but as to the instant motion, I was actually going to offer a friendly suggestion. Is Mr. Ng around? Great. Could we maybe swap items 2 and 7 so as to hear item 7 first, as Member David was suggesting, and move item 2 back, because I understand Mr. Ng is also here on item 9?
Oh, that's,
Yeah.
is that correct?
Yeah, I'm also addressing item number 9.
Right, so that's what I'm saying. If we moved all of your stuff back and moved that up, then everybody sort of wins.
The friendly amendment is accepted on my part.
Okay? Everybody, audience, okay, all right. That's my suggestion on that, and then I had some other comments. So
Okay.
why don't we address the
Why
motion
don't
first?
we address the motion? Is there any public comment about moving item number 7, just switching places, item number 2 and case number 7, item number 7? If there's not, public comments closed. Can we take a roll call vote on this item?
Or without objection? Or without objection? Okay.
On that motion, Member Nee?
No.
Nee, no. Member Washburn?
Aye.
Washburn, aye. Member Pilpil?
Aye.
Pilpil, aye. Member Sims?
Aye.
Sims, aye. Member David?
Aye.
David, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Vice Chair Fisher?
Aye.
Fisher, aye. Chair Grant?
Aye.
Grant, aye. The motion passes.
Great, okay. So we're going to swap that out. So item number 7, file number 13031 will be heard next after we go through this. We'll move this to number 7. Okay. Member Pelpel, you said you had some other agenda changes.
Right. Regarding the agenda changes overall, when there are these late requests to continue items or to withdraw the complaint, if it's possible to just make at least one set, if not a set, for all the members so that we can see who it came from and where, that would help
We
me.
just got an hour
I
ago, so.
understand, but at least to have a copy that we can circulate, and if there's something that comes in 3 days before, if we can have copies of
I
that.
have a copy
at
of
the
this
meeting.
if you want to.
Okay.
So I do think he did the best he could
Yeah,
in
no,
this
I
case.
understand.
so.
I'm just suggesting that as a matter of process in the
Yeah.
future. As to the other items, item 3, if that was withdrawn, then that's disposed of. That's the end of that. Item 6, and I assume that if item 3 was withdrawn, that the respondent will be notified.
Item 3?
Right.
They came to a conclusion together.
Okay, so they all know.
Yes.
Okay, cool. And item 6, and as to item 6 and 8, I would so move to continue to our next meeting.
Second.
Second? Did you second?
Member Nagy.
Okay. Okay, great. All right, did you get all those changes?
Yes.
Okay.
However, I believe that Item 6 was a request to continue to February, not to January.
Got it, okay, so 6 to February, 6 to whichever meeting in February.
So yeah, just
Continue
February.
them as requested.
Just continue.
Is there any public comment on the agenda changes? If not, public comment's closed. Can you read the next item?
We need to vote.
Oh, we didn't.
Do you want to do that without objection?
Without objection.
Oh, okay. I believe this motion is passed without objection. Okay.
All right.
Next on the agenda will be item number 7. Item number 7, file number 13031, complaint filed by Amber Strauss against Delmas Scott Skillman, interim chancellor, City College of San Francisco, for allegedly failure to comply with the public records request.
I believe there is an issue of jurisdiction. I'm sorry, who are you? Tell me.
Sorry, Scott Dickey on behalf of the San Francisco
The other
Community
mic.
College District.
Okay, use that mic, because that's, yeah.
Okay.
So we can.
Sorry, Scott Dickey on behalf of the San Francisco Community College District.
Great. So you have 5 minutes to tell us what the issue of jurisdiction is.
I'm sorry, can we also note, I think there's a typo here, Thelma Scott is S-K-O-T-T?
It's SC.
S-C, excuse me, but no H.
No H.
Got it.
No.
All right, thank you.
Thank you.
The San Francisco Community College District is not subject to the Sunshine Ordinance. It is a separate political subdivision of the state of California. It is created by the state legislature, and its elected officials are selected by the voters at large. Because of that, this task force has no jurisdiction over this complaint, and we ask that you dismiss it on that ground.
Okay, thank you. Is there anyone here that wants to offer any public comment in support of Mr. Dickey? If not, I'd like to invite the complainant up that's you, to talk about this issue. We're talking just about the jurisdiction issue right now. So whether we can hear it, what is your reasoning of why we should be hearing this case?
I feel that the failure to share press releases exemplifies a crisis of...
Please talk
Excuse
closer
me.
to the mic.
Oh, I'm sorry.
Yeah.
I feel that the failure to share press releases exemplifies a crisis of transparency demonstrated by the newly outside administration at City College.
Point of order, Madam Chairman.
Ma'am, can I interrupt you?
Yeah.
So jurisdiction is whether we have the authority to hear that. Based upon what Mr. Dickey said,
Yeah.
because of who the City College of San Francisco is elected by public, we don't have that jurisdiction.
Okay.
So if we don't have jurisdiction, we can't even hear the case, the content of the case. So it doesn't matter. We have to get past that first point. And as of now, according to him, and I'm going to open it up to the members, but it does seem that we do not have jurisdiction to hear this case, which I don't know if you knew that.
I was unclear on that.
You were unclear on it?
Yeah.
Okay. Can you, Ms. Lee, can you explain, I know you put in your memorandum the reasoning.
Mr. Dickey, counsel for the Community College District, pretty much summarized it. It's a political subdivision of the state of California. It is not under the Sunshine Ordinance, which is an ordinance for the city and county of San Francisco. It is City College is not a department of the city, is not a body or a policy body or legislative body that is subject to the Sunshine Ordinance. And the Sunshine Task Force hears violations of the Sunshine Ordinance.
Okay.
DCAD, I just want to clarify. It also like San Francisco Unified also San Francisco Unified School District also is not. The Sunshine Ordinance does not apply to it in the same manner that it does not apply to community college. Is that correct?
Correct. I'm not entirely sure of the statutory underpinnings, but I believe you're right.
Okay.
I mean, there are several policy bodies and other districts and bodies that, by reason of their origin, and their establishment are not subject specifically to the Sunshine Ordinance. And yes, San Francisco Unified is one of them. Not sure if it's for the exact same reason as Community College District, but you're correct.
So if you have no jurisdiction, I can't really speak, right?
We can vote on this issue, and it depends on if the rest of the commission decides that they believe that that there is jurisdiction against what Mr. Dickey says. So let us deal with that matter before you deal with the issue, like the issues. So we need to deal with whether we can even hear it, because it's a waste for you to even get to that second part yet. Okay?
Thank you.
All right. So is there anyone here in support of the complainant? If not, then I would like to open up to the members. Member Pilpel?
Okay, so this has some history. Member Nee will recall this. I think, Mr. Dickey, are you now with the district? You're not with the city attorney's office anymore? Is that correct?
That's right. I used to be with the city attorney's office. I'm actually with a law firm that represents the district.
Okay.
At this point.
Mr. Lee retired as general counsel?
Ron Lee retired as general counsel in 2010.
And Ms. Batiste is?
Ms. Batiste was general counsel until November of 2011, and I took over from her
As a contracted?
as a contract general counsel until...
Okay, so we had extensive discussions at this task force many years ago about whether it applied. A close read of 67.30 talks about requesting that other agencies like and the Colorado District adopt policies quite similar to our policies. We had, in this case, College District folks, Peter Goldstein, Ron Lee et al., ultimately resulting in the College Board adopting, and Member Nee, again, will recall some of this, adopting their own sunshine policy, and I believe actually creating a subcommittee within the shared governance system to address complaints of noncompliance with their sunshine policy. I don't know if, under the latest restructuring at City College, if that committee or subcommittee still exists, but we had lots and lots of hours spent in this room and others about this topic, and the bottom line is that the College District is not subject to Chapter 67, but they have adopted their own policy, and so I would strongly recommend Ms. Strauss to find out from Mr. Dickey or however what their grievance process is within the district relative to her records request. But I would agree that we do not have jurisdiction. I'm happy to expound further if necessary.
Member Nee?
Yes. I would also like to point out to Ms. Strauss, if she feels that her complaints are valid, particularly under the California Public Records Act and or the Brown Act, even if she can't come to us with it, there are other alternatives, including the courts, and there are a number of sunshine advocacy organizations that might be willing to help her wend her way through the process. One is Californians Aware, and the other is the First Amendment Coalition. And I think everybody here should be aware of those organizations in case they come up into similar straits. The fact that if this is not within our jurisdiction, that doesn't excuse the community college district if it does in fact violate the sunshine laws, the state sunshine laws.
Do you kind of understand what Member Nee was just saying? Just so you're clear. You get it? Oh.
Good.
Okay, cool.
I'm sorry, just one quick follow-up. Sorry, Mr. Dickey, what firm are you with now? Is it Moscone and Friends?
No, it's Rooney Sloan Holtzman Sakai.
Oh, it's the other guys.
Yes, the other guys.
Thank you.
Very much. Okay.
Is there any public comment on this issue? Do you have a question? You can just... You're the complainant, so you come on up.
Yeah.
We no longer have a board at City College. The board's been deposed, and we have a special trustee with extraordinary powers, which is against the will of San Francisco people, right, who voted for the board. And I feel that the current climate with the ACCJC, with a special trustee with extraordinary powers, demonstrates a lack of transparency, and our union has been having trouble getting public records acts responded to. So that was why we were hoping that, because City College is a beloved institution, an important institution in San Francisco, the Sunshine Ordinance Task Force might be able to use this ambiguity and this time of political turmoil and confusion to shine a light on what's happening.
Okay, that's fair enough. Thank you. And I can't speak to that, but I'm going to try to speak to it. It doesn't, even though that's going on, the bottom line is that we don't have jurisdiction over City College, right? And so no matter what the changes are going on, but like Member Nee said, I really strongly suggest you go to some of those other advocacy groups, and I think that they might be able to kind of guide you in a way that you might be able to get some results. Okay? Thank you. Member Pilpel?
I'm sorry, once more to Mr. Dickey. I gave a very encapsulated view of the world there. Are you aware of the sunshine policies of the district generally?
I am generally, yes.
Okay. The committee that I referred to, are you aware if that still exists?
I do not know the status of that committee at this point. There was a dramatic reorganization of the shared governance process back in January, and I can't tell you standing here how that shook out for all of the committees.
Understood. We certainly can't compel you, but could I just request if you could take a moment either today or when you're back at the office to figure out what the dispute resolution process is within the district and advise Ms. Strauss, so that I believe that there is something that exists, whether or not the board is meeting, that there was some policy, and unless the special trustee undid that policy, which I doubt.
I don't think you can advise.
I can't.
I'm not going to be able to advise her, but
just to point her to whatever resources so that you can attempt to resolve that within the district.
I think
that's all.
Yeah, I think your first bet is to try what Member Nee was saying. I think those are some really good options for you, and then you can come back around.
Thanks.
Yeah. Thank you. At this time, do we have a motion?
Well, I just want to add one thing. The new chancellor of Community College is speaking tomorrow night at Friends of Noe Valley and the Noe Valley Democratic Club. It's a group, a different bunch of groups are all meeting at St. Philip's Church in Noe Valley. I believe it's 7. It might be 7:30. You might want to check on the Noe Valley Democratic Club website, and you might be able to get some of your questions answered directly from the new chancellor of Community College. So I just wanted to make you aware of that.
Great. So at this time, do I have a motion from the members regarding jurisdiction? Why does one have to?
I'll make a motion to not find jurisdiction. I believe.
Point of order, Madam Chair. I think a proper motion would be to find jurisdiction, and if no such motion comes forward, then the matter is concluded.
Okay.
Who just made that? Oh, you made that motion.
I will withdraw, so we don't have to record that. That's cool.
So do I have a motion regarding jurisdiction? No? Okay. So there has been no motion regarding jurisdiction, so this matter is concluded.
Public comment.
Is there any public comment on the matter of jurisdiction? If not, I'm going to close it, and I'm going to conclude this matter, and hopefully you'll take some of the suggestions and kind of work that way. Thank you both for coming. Great. Mr. Young, can you read the next item on the agenda? What did we just do?
Item number 4. Number 13024. The Clients Amendment Committee has referred file number 13024, Nika Ringo, against the Planning Department for allegedly failing to provide requested records associated with the proposed development of 480 Potrero Avenue.
Member Washburn, as the Chair of Compliance Amendments, can you update the task force on this?
We heard this matter was referred to Compliance and Amendments by the full task force at the November meeting, and we heard this matter at our November meeting. And at that time, we determined that the Planning Department had not provided all of the requested records. We thought that the bulk of the outstanding records were probably on backup tapes or archived, and we were urging the parties to work together to resolve this, and we referred the matter back here to be heard by the full task force. Member Nee, or do you have anything to add?
Madam Chair, coattailing on what Member Washburn has told us, I believe what we decided was that the parties, particularly the Planning Department, should seek assistance from the Department of Technology in retrieving communications that had been destroyed, had been deleted. And so that's where we are now, is we want to find out what, if anything, has been done in that regard.
Sorry about that. Can we get an update? Oh, here we are.
Lulu Huang from the Planning Department. From the last session, we are requested to get information emails, particular from the DT, and which we did request it from DT, and they gave us a CD. So I have one CD for Micah and one CD to submit to you. And these are all of the file from the new system from 2012 till now. And that's all we have. If you want anything else, I think we have to make a special, really special request to get it from the Lotus Note, which is already almost obsolete, and they probably will charge us for it. Okay? So this is for you, and that copy.
Thank you so much. Is there anyone here who want to offer any additional public comment, any additional support for Ms. Huang? If not, I'd like to invite Mika up. Is he right there? I can't see. Okay. Hi.
Good evening.
Mika, sorry.
No worries. The task force is the only place where citizens can file a public records complaint without an attorney or a fee and compel a city official or a department to come before the task force questioning and a ruling on whether they had violated the Sunshine Ordinance. And I did that. And I waited for several months because you all had a backlog of complaints. The very first words I said at the very first hearing on this matter were that the planners really should be here. They had sent Lulu Huang, who hands you the files from the front desk, but as far as I know does not review files and knows nothing about what I was asking for. Lulu Huang, we went through the hearing. They were told to comply. It was clear they weren't complying, so I emailed asking for an order of determination. I got the order of determination, and they still didn't comply. It went to the compliance committee, and at the compliance committee, Don Lewis, Ben Fu, Lulu Huang arrived 15 minutes late, and I was the only item on agenda. And then they provided testimony that, well, they had talked to DPT, but nothing had been ordered, that a city attorney had told them they didn't really have to comply, that there was some sort of privilege, public privilege. And I have court printouts saying, from case law saying that that doesn't apply until after a project is approved. For them to come in late and to offer testimony, I've been damaged by not having access to what's on the CD. And I'd like to point out that on the order of determination, it says I was already given the case files on a CD at the first complaint hearing, as if it was a token to, and as if it was what I had been asking for. And indeed, on that CD was exactly everything I had already been given, which was not the substance of what I had asked for. And you're a city attorney, who I think understands the laws the best and who wrote an outstanding write-up of the summary of events in the initial complaint. At the first hearing, I was, I think, a week before the Board of Supervisors hearing. The compliance hearing, I was a day before the Board of Appeals hearing. And now the project's been approved and litigation's actually now begun. So for me to get the CD now, I am appreciative. I thank you all very much for helping me get it. But as far as, was it willful? Yes, it was willful. I have no doubts that it was willful. It was willful from the very beginning. I have repeatedly, even to Sarah Jones, who's the head of environmental planning, who's here today, she should have been here at the very first hearing, or she should have been here at the compliance hearing. And so whatever's going to follow after this is going to be some excuse and explanation for their delay, so they have successfully delayed until the project was approved, and now they're complying. And you all are very powerful. People are very afraid of the Sunshine Ordinance in San Francisco. I mean, as far as I can tell, everyone's worried about the Sunshine Ordinance. If you're a city official, I mean, obviously, if you're not a public servant, then you're not. But, and there are significant ethics, as far as I understand it, within the meaning of the Ethics Commission and the regulations for complaints alleging violations of the Sunshine Ordinance, about whether this was deliberate. The information that was withheld and then given to me immediately before the hearings were scheduled that were really questionable things, failed technical studies, you know, on and on. I don't have much more to say other than that I have no idea what's on the CD. Are we going to come here again? The city attorney outlined, I had asked for PDFs, word processing files, spreadsheets, everything within the gamut of, oh, one last thought. As far as the emails go and the correspondence, they were saying everything had been destroyed or that they had been deleted and they were gone. Who deletes what's in their sent folder? Indeed, if you get an email and it's important, you reply. And therefore, there is a copy of the email thread in your sent folder. And so I don't buy any of what the planning department has provided thus far. And I'm happy to have a CD. But at this point, I've been irreparably harmed in a sense. And the process has been thwarted by their noncompliance with the Sunshine Ordinance. Thank you very much.
Sorry. Thank you. Is there anyone here that wants to offer any support for Micah? Micah? I'm trying to get it right. Sorry. If not, then I'd like to open up to the task force members. Member Nee.
Ms. Wang, please. I have a couple of questions for you. First of all, have you seen what's on the CD that you just handed to us and to Mr. Ringel?
I didn't read everything in the CD, but I was the one who put all of the email file onto the disk, yes.
Okay. Second, why are you waiting until today to give it to him?
I just got this file like yesterday, late Monday, sent it over to us, and then I will deploy it to the planner, and then I put it on and bring it in today.
Okay, you got it from whom?
DT.
Okay, thank you.
Yeah.
Victor, does the laptop there take CDs? You know? I think we should at least see what the files are, so we can see what they're doing.
Micah, do you, is there a list that was provided, while he's doing that, is there a list that was provided of what is on that CD, or what?
If all the communications were from, I think she said late 2012 anyways, my complaint was open prior to late 2012, well, mid to late 2012, October, November. No, I maybe didn't open it until early 2013. So I don't know. I know the project's gone on since 2011, and it's the original correspondence that I was most interested for.
So if this is from 2012, is this going to, I understand your concern that you've been damaged and all the things that you were saying, but I'm wondering if,
Well, is it just from the planners too? Because I asked for everything held in the custody of the planning department.
Well,
that's kind of like what we need to know. So I just was wondering if there was a piece of paper that was given to you, or when you just got the CD. So she just handed you the CD, okay.
Just like you guys
Just so you can just double click on that.
So if you see this and you see that it's what you were asking for,
If there's not Word documents, if there's not, I mean, it depends. Some of the documents that I had been asking for I got were photocopies of PDFs of emails that came from their printouts of their emails, and so they weren't searchable. None of them had OCR recognition. The graphics weren't attached to the files.
so let's see what,
No attachments.
okay, since he's opened it, here's what's on it.
Okay. While that's happening, I might go down. Ms. Wong, maybe if you could join us again.
Micah, you have a question?
Initially looking at it, the first email is from 11/21. They appear to be since I made my complaint. So that was the original issue. Okay. So hold on, I'm not prior.
Understood.
There's another file, though, a 2 gigabyte file.
While you're looking at that, if I could just ask Ms. Wong, can you give us some general description, I think it's the center, of what you understand to be these two files in CD?
What I understand from last meeting, that we have been here for many times, and we are still puzzled and what did we miss, and we would want to help my best to get what he wants. So the last thing that we get the instruction from the commissioner was get all the email requests from DT and give it to Micah, which is, this is the disk.
So that's the gist of everything, the email that's
Right.
there.
Yes.
That's what was requested in the compliance
right.
amendments, if I recall correctly. Okay.
Okay, so it seems like this is a set, 2 PDF files containing a bunch of emails, some before, some more recent, related to 480 Potrero.
Yes.
Okay, so some of that Mr. Ringel may have had, some of it may not, he may not have had, and maybe won't. Can I also inquire from planning, whoever wants to respond, were there any paper records that you were able to find related to that address or this case number in citywide, neighborhood, or environmental planning files anywhere within the department that had not been disclosed to Mr. Ringel pursuant to his earlier request? Did you do a further search? And if so, did you find anything?
No, we do not have any more files.
Did you do a further search?
Yes, we did.
Okay, and you found?
And whatever file that we have, we already given out and, for him to come review. All the files.
And that includes, again, citywide, neighborhood, and environmental planning, the entire planning department related to this address and that case?
I believe so, yes.
Okay.
I have a question for you. All the files we're seeing here are PDFs. Did you take Word documents, Excel spreadsheets, other communications, and put it all in PDF? Or is this only the PDFs from the files he's asking for?
These are the PDF files that we get from DT.
Okay, so there's other Word documents that are not included in this list?
Yes, because we are complying to get all the email.
Okay, and you emails saved as PDFs?
No, these are the email that's given to us from DT. That's how they give it to us.
Okay, that's what I was just
Yeah.
format.
Right.
So, let's follow up on that. To the extent that the department has any electronic files not email, but as a doc or a spreadsheet or another PDF with photos and shadow studies, whatever the heck, where are those electronic files and have those been disclosed to Mr. Ringo
Yes,
already?
I have given Micah and not the city, the other day I gave him another CD, which we have all the people who have this file, put it in a folder, whatever.
And was
I
that,
gave it to him.
was that the October 30th meeting that was referenced in the email? Where you said, I've got something, and Mike just said, sure, I'll be down next day?
That was that CD, October 30th, yes. It's either October 30th or 31st. That was the day that I given him the CD and we had it.
Okay.
Yes.
Thank you. So back to Mr. Engel. So can you tell us about the CD that you got on that day and what was on there?
On that day, Don Lewis had nothing. His folder was actually empty. There was a folder with his name on it. It came from the iDrive, which I believe their shared network drive. His files that were on the iDrive were deleted. So I got a CD with the folder that was empty. From Ben Fu, all that I got were, again, my emails to them, or their responses to me, and something from Lulu saying, help me out, guys. Since you both decided not to go to the task force hearing, that was the first hearing, can you help me out with any other documentation that he's asking for? And so there was a willful choice that they decided not to come when they received your summons to come to the hearing. Okay. The email I just am looking at here, this email is so important of the substance of what I was looking for. It was the basis of an entire appeal at the Board of Appeals. And had I had this, I would have had the concrete proof that I had been asking for months. And this is just amazing. I can almost stop there looking at it. And then the other thing is they stopped at 2012. I can't afford to pay for the recreation of them. But I don't understand why the records aren't maintained prior to August 2012, middle of August. If there were ongoing cases that hadn't been decided yet, there must be some record of them or a way to recreate them. But okay, this is like really. Thank you for getting me this much. It's just
So this answers a lot of the questions that and this is what you were looking for?
yeah, but it's like getting a Christmas present in August. It's like thanks, you know. I'm happy I got it.
What's
but
late or maybe early? So you might actually, this might have information that might be a basis for which you can request rehearing before the Board of Appeals, but that's up to you.
No.
I'm saying that's up to you. Are these, to the planning department, are these emails that had been deleted or emails that were in the system and needed to be retrieved from an archive or some other way?
Yeah.
Were these current emails or deleted emails?
Because there's system, we got email all the time, so there is a system that certain email will delete by itself.
Okay.
So that's why we need to request through DT, and because all of the backup file will be at their server.
So what's on that CD?
That is what we...
That's deleted emails or a combination of deleted and current?
I don't know. Deleted will not be here. Because it deleted, it will be not living in the server.
Okay,
This is
so
all...
not deleted.
Archived, right?
This is archived but not deleted.
Right.
Okay.
Yeah.
Okay. So I guess we're still trying to figure out if we've got all of the email, if the other electronic records, docs and PDFs and whatever had already been provided, and if all of the paper records had already been provided, then is there anything else that planning has that Mr. Ringel doesn't have on this matter?
No.
And what planning is saying is no. And then to Mr. Ringel, is there anything else that you believe exists that they're saying they've already given you? Let's figure that out. That's what I would suggest.
well, the correspondence prior to this would be one. I mean, I suppose it's in their domain, and they could have gotten it.
The correspondence prior to what?
Prior to the date of this, they said that this is from their backups that they had on their server, although they had to access them from DT, but that this is changed from the previous, I believe, exchange in that system, and that those would have to be off-site storage backups. And so, I was looking at it. It's August 3rd or August 11th. And that would actually be right prior to the negative declaration process. The case file itself is the version 1 of the environmental application is March 2011, I think. So
So you're saying it's not there and you've not ever received that?
I haven't even ever received all this right here.
Okay. So just from, and I'm going to ask Member Washburn, the Chair of Compliance Amendments, the whole issue which we brought up at that meeting was Lulu was going to try to help, was going to try and get the missing items. And we weren't going to be able to get them the next day because I believe your hearing was the next day. But she was going to go to Department of Technology, if I recall correctly, and get that all the information that you're requesting and things of that sort. And so this is, when was our meeting?
You know that, right? It was last month in October 3rd or something. But you had missed the very first hearing, like the one with the full board or many of the board members, that they had been told that before. And after the October 3rd hearing, or prior to the October 3rd hearing, in between the two, I had to ask for an order of determination because there was no contact. And there was no, and then they showed up at that hearing, and then they proceeded to provide the reasons for not providing contact, including that it was protected under the work privilege, that it was non-substantive was a big part of it, and that was a big part of the attack. And so I brought a couple emails if you're interested in the non-substantive emails that I was speaking of, and you can leave this aside if the fact that there were huge notification problems. One of them, which I was on the telephone with today, with the California State Deputy Attorney, with regards to how this is affecting the community. I wasn't the only one who brought up these issues. And so when he said there were no substantive emails, I brought you just a couple of them here today so you can decide whether or not they're substantive. Even these are substantive here. And so these all existed all along. They didn't want me to have these because these refute that's all ethics. And so as far as, is it okay, the question I would like to close with is it okay for them to comply now?
So it's a matter of timing. You didn't get the stuff that you'd asked for before. Member Washburn?
I'm just wondering if you have some new information for you that you got today, but I hear you saying that there's at least a year and a half's worth more information that you haven't received prior to this.
Yeah, she was saying that this is since their servers switched over and that they were able to access these, which really they should have done months ago if they were able to. But the other ones would have to be recreated from off-site backups, and that they would have to pay, or the department would, or there would be a cost or something. But no one's ever even been willing to provide me this much or provide me for a reason with, no, we're not going to provide them to you, or no, you're not entitled to them, or no, there was no explanation, there was no assistance, it was a cold shoulder, and that's all you're getting.
If I recall at the compliance and amendments, we were considering records that would have been off-site and, backed up, archived, and you asked for all records related to this matter, and that means all records. And it is not up to the departments or agencies to decide, oh, this is substantive and this is not substantive, and oh, this is something that, doesn't pertain. When you ask for all records, you mean what you say. And so it was my understanding from our hearing last month, compliance and amendments, that we were asking, planning, work with IT to get all the records. And so they've only gotten the ones that were fairly easy to get, not the ones that required some additional work. So,
and to stay in contact with me about it.
And what?
And specifically to work with me on getting them. That there should have been communication since then. There's never been any. Lulu Wong, prior to compliance, had sent, what is it that you're looking for? And she made several inquiries. Every time I told her what I was looking for, it was always the same question again. Well, what is it that you're looking for? Well, what is it? And so much so that honestly, I thought after the first hearing, I needed the order of determination to, which there have been 7 granted to 5 people in all of 2013, mine's number 7. And I'm wondering if the other people got what they wanted after they got an order of determinations, or how many people go to compliance and then come back for getting very little. And even now it's like, okay, well, we'll give you to 2012, here's some of it, but not all of it. Or if there's not one Word document, and Word documents were asked for, and would assume that, it just goes on and on. And so at some point, I can draw the line and say, well, I guess the record's clear enough now saying there hasn't been compliance. But, it all goes back to why hasn't there been?
Hey, Lulu, can you come up here and kind of respond to, because I remember in compliance amendments, you were going to go to DT and you were going to try to work to get the items that you said had been archived and were no longer, I remember all that.
Right.
So why, and you just mentioned that in 2000, so you got all the stuff that you have, but you mentioned in order to get the stuff prior, you'd have to go make a special request or something? What is that about, and how can you make that request?
Whatever email that we have in our system, we already gave it to Micah. And then he said there are more. So it's been backed up because all the email, you cannot store all email in the system. So it gradually back up in the DT server. So this is what we request DT to go to their server and draw it out for us. And this is the new system. This is the Office 365 or something. But before that, we have the Lotus Note. And that is another server, which is almost dead. So if we need to recreate that part, like Micah said, this is only from 2012. I already said it from the very beginning. This is from 2012 till now. Whatever you need beyond that 2012, we have to put another order to get a quote, to get a PO.
Have you started that process?
No.
Okay.
Because,
you
we
thought
just
this
got
might be
this
enough? Oh,
Monday night. We got this Monday night.
Okay.
Okay, and the person who take care of this thing, he was sick from Tuesday to today.
Got it.
Yeah.
Okay. All right. Thank you. Member Pilpel.
So to further clarify, can someone head over to the laptop? For example, not this particular email, but the next one. It's referring to an attachment. Can we figure out if the attachments are included here or just the email itself?
It does appear that there are attachments. I'm familiar. This is a PDF portfolio, and the attachments in their native format are encapsulated inside, so I click on the attachment.
Can you just check to be sure? Because I don't want to leave here and say, oh, we thought it was there, but not so much.
Could you please talk into the microphone, Mr. Ringo?
Certainly.
That's looking good. Let's see if it's there. Hey, rock and roll. Okay. So that's actually a lot of stuff there. Yeah? Yeah.
Since August 2012, and the case file was opened early 2011, so there's a whole year missing. And I understand technology fairly well, and so what they're saying about the Lotus Notes program, everything can be imaged, basically, and so it's like a virtual disk. And so someone in Department of Technology without any work can load up the file that is as if the server was created, what it was backed up to, and load the backup thereof of the mail thing. It's only a couple clicks. It's not like the server's almost dead, we can't touch it, or whatever. It's if they could do this from backups, they could do that through a virtual machine, and they no doubt have virtual machines. It's what IT people do every day. It's not anything special for them.
Well, you lost me on that, but I think I get the concept.
Yeah.
Lulu, did DT give you any kind of cost estimate or time estimate on...
She said she hasn't requested that yet.
But in their communication to you on Monday with this disk, did they say, we can do this and it'll take some amount of time? Did they give you any kind of cost or time estimate?
We have not started
No.
because once we get this on Monday night, So we processed it.
Right.
And then we said, okay, let's take this to the task force. And then if they require us to get more, then we need to write another request.
Got it, okay.
It sounds like we may be headed there.
Okay.
I guess my summary on this, not just specific to this case, we have had a number of complaints with planning over the years. I've dealt with Lulu for many years and the other staff people. Do we have, I guess every time I think we've got a process in place and people make requests and things fall through the cracks and we do what we can to fix it, I guess I'm just thinking out loud, do we really have a process in place, or do we just continue to have all of the exceptions? If someone says, I'm looking for all this stuff about this particular file, why does it end up being so hard all the time to just reply to the request, whatever their view is on an underlying planning matter? I guess I'm frustrated that we continue to get all these complaints about planning, and every time we try to have a hearing and think that we fixed it, something else comes up. I would like not to continue to be in this place. I don't know if anyone has an answer to that. I'm frustrated.
Sarah Jones, Environmental Review Officer from the San Francisco Planning Department. I think one answer is that often requests are made that might point us toward certain information that do not point us toward the entirety of the information that's available, and then there's a lot of back and forth. There is also a substantial amount of time and cost involved in the records requests. We do try to find out exactly what people are looking for and provide them what they're looking for. Many people don't like it if they get reams and reams and reams of paper and documents and files to go through, which is what's in our files. There are also attorney issues who the attorneys have to go through and review all of the information as well. So there are many complications in complying with public records requests. We do try very hard to do the appropriate thing, and it is a difficult system to work with.
I guess I remember a conversation with Mr. DeSanto where he indicated that the record management function that Lulu has been running through operations was going to get transferred to the commission secretary when a permanent commission secretary was hired. I understand that Mr. Ionin is now the permanent commission secretary. Is that correct?
Yes, he was very recently appointed permanent commission secretary. Less than, I believe, somewhere in the neighborhood of a month.
A month ago. Okay. Do you know if it's still the department's intention to transfer that function under him, and whether that's Lulu or somebody else, if that is going to move department-wide under the commission secretary? Do you know that?
I can't speak to that. Perhaps Ms. Wong can.
Okay. I mean, I guess part of the concern here is that, as I indicated earlier, you've got neighborhood planners and files and structure, you've got citywide, and you've got environmental, and they work together, but they are still somewhat siloed. And the record keeping, in my experience, is even more siloed. And the goal of having an operation/records management function that's not housed within any of those three is so that they can sort of break that down and say, look, I'm interested in everything, let's find it and get them the stuff. So maybe with this latest restructuring, we'll get better?
Well, we're also transferring to a new permit tracking system that will make the case files themselves more readily connected to one another, rather than a lot of different files for different aspects of review of a single project.
Those C&E files will still be separate, but?
So our whole permit tracking system is changing, and that could contribute to improvements.
Okay. I mean, maybe I need to hold a hearing at EOT and explore this more, but I feel like we've spent a lot of time with planning over the years, and we're still doing that. Anyway, I don't know. I don't want to belabor this much more. But
So why don't we move forward, and let's see what the members have anything to say about this. But before I do that, do you want to say anything? Who goes first? Lulu. Right? Yes. Yes, the respondent. Do you have any last remarks? Because we'll figure out what we want to do based upon kind of everything that's been said right now. Before we make a ruling? No?
No.
Okay, thank you. Micah, do you have any last words? 3 minutes.
This came from the State Attorney, 2004. In enacting the California Public Records Act, the legislature stated that the access to information concerning the conduct of the public's business is a fundamental and necessary right for every person in the state, and that everything should be emphasizing that its primary purpose is to give the public an opportunity to monitor the functioning of the government. And that's the issue for me here, is that I have been successfully denied that by the respondents. Thank you.
Thank you. I'd like to open up to the task force. Is there a motion or anything? Member Nee?
Madam Chair, I'd like to move that this matter be referred to the Ethics Commission.
Do you want to say your reasoning? Or we would...
If there's a second, I'll be glad to.
Second.
It is apparent to me that the planning department deliberately dodged the complainant's information request. The fact that all this new information has come forth today means it was there, and the planning department should have gone after it the minute that request came in. Instead, here we are so much later, and there is reason to believe that the complainant still does not have all the information that he requested, still does not have all the information that he should have. This to me smacks of willful misconduct.
There's no comment, then I'd like to take a public comment on this issue. If there's no public comment, I'm going to close public comment to this issue. And Mr. Yang, if you could take a roll call vote on this.
On the motion to refer to the Ethics Commission, Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Philco?
I'm not convinced that a referral is warranted at this time, but I am troubled, so no.
What is your...
No.
No. Philco, no. Member Sims?
Aye.
Sims, aye. Member David?
No.
David, no. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Vice Chair Fisher?
No.
Fisher, no. Chair Grant?
No.
Grant, no. We have a vote of 5 to 4.
Okay, so did not pass. At this time, I don't know if there's anything else anyone wants to say, but the matter's concluded. And Member Washburn would like to say something?
Yeah, I'm really distressed about this. And I'm reluctant to let it go. So I'm wondering, would it make sense to send this to EOT to at least work with the planning department to see if they can't develop procedures so this type of thing doesn't happen again.
Yeah.
I think
I'm also a little distressed that certain members of the task force talked about their frustration and the history with this, yet didn't have the consistency to vote with the motion.
We can make that second motion, which we can create it. Celia, we can do a new motion, correct? Yeah.
We would need to rescind the previous vote before taking a new motion.
Okay.
I think not. I think
We can just make a whole new motion.
related to this item, I don't think we need to rescind the prior action. I think we can take another motion that's related to this matter. And we have in the past had a question of referral where it has failed, or we have chosen not to send it to ethics and we sent it to EOT. And I am absolutely willing, and let me say for the record, I am certainly open to being persuaded, and so this might be back here, and if my happiness doesn't increase, I may.
And just to summarize, as a task force, what have we found so far? We found they're in violation, correct? And
I think the concern is, though, is that it is, it is in violation. No, let me take that back. They've made efforts. We also are concerned with when the departments are making the efforts. So it's a little bit of confusion. So she went back after compliance amendments and did go to DT. They did do what they were going to say. The timing is off. I understand all that. So it's kind of fuzzy, a lot of this.
we don't want to punish departments for them finally coming up with information. That's not the message we want to send. However, in this case, planning is an important department, as are all departments, but if this information had come forth earlier, it might have given members of the public grounds for changing this project, for stopping this project, for weighing in. That's the whole purpose of this. He was denied that due process. That's clear. And the fact that it's not that the documents weren't there, they were there all along. I'm sorry, a year later, or 18 months, whatever it is, it's not acceptable. So, we can go through all the motions and the EOTCs with us, but in the end, that's where we're going to end up, I think. And why not just get straight to the point? There's some history here. Planning has had its issues, but we're not looking at that. We're looking at, there is some institutional knowledge here that has said that we've run up against planning for compliance with sunshine in the past. So why not save, all the public's time and money and just get to that point now?
I guess I think that we need to judge each case individually. We can't make a grouping about their precedents. So when you look at this case, it's up to each member to decide what, how they feel about
Fair
this
enough.
case.
Then if you like, we can go through the steps. We can refer to EOTC if we're not satisfied.
Which is not exactly, which is what Member Pilpel is saying.
Send it back to the full task force, and maybe that's the appropriate time.
Rather than just, the motion just dies and then it just, because people do feel strongly about it. So this is the way to keep it alive in the middle.
However, in the interests of being efficient and not adding to our backlog, which is an issue, I don't want to not have justice served, but, there is some discretion that we should apply to bouncing cases around and adding to the backlog as well, so it's a balancing act.
So if a motion is made about sending it to EOT and second it, and that goes through, then as the members of EOT, then that's kind of up to you guys to bring it back with some really viable things, if that's what you want to do.
Well, I'll see you and I'll raise you. If we make a motion and send it to EOT, we still haven't finalized the agenda for Monday. If Mr. Ringel and planning are willing, let's do this Monday afternoon and see where we are 5 days from now.
If that's enough time for that.
And so you can initiate something with DT, tell us where you're at, and let's talk about reorganization at planning, and let's keep this moving.
If I may, could you please say what EOT is?
I'm sorry, we're talking
Thank you.
shorthand. The Education Outreach and Training Subcommittee Committee of the Sunshine Ordinance Task Force, which is next meeting Monday afternoon at 3 o'clock in this room.
And explain to the purpose of it.
And that would be a hearing to follow up on what we've just been talking about, where we are with DT on the backups or whatever email, whatever procedures are in place, whatever reorganization is happening within the department, what policies and procedures are in place to handle these things going forward, including Mr. Engel's still pending matter.
And that's a matter that it's not appropriate to involve specific planners who might be working on a specific project. It's more of an overall departmental question.
Yes, exactly.
Future. Well, it's not a question. It's that the EOT is going to help work with you to get the policies that allow for the transparency so this kind of stuff doesn't happen. Because what you're saying is that you didn't know, or you didn't get it in time, or and all these things were happening, but that shouldn't happen. And so what he's, Member Pilpel saying is that he's going to work with you at this meeting to try and develop policies that you can work together that will avoid this from happening, because Mr. Ringel, there are a lot of people like him that come.
I understand it. So all I'm saying is that this isn't a matter that Mr. Lewis, Don Lewis, who's the planner on a particular project, would be involved in. It's more a question for department administration.
That's correct.
So are you guys, wait, so are you guys, did you say you're willing to come on Monday?
I'm not the appropriate person to come. I'm the director of the environmental planning section of the department, but
Okay.
I'm not part of the administrative staff of the department.
The reason I guess we're asking, so would that be Lulu?
That would be something to discuss with Lulu,
Okay,
yes.
because if we put that on the agenda, if we make a vote and you guys don't show up, then that's not going to be good. So is this something that's possible? So Lulu?
Member Oka had a comment as well.
Let me hear what she says, and then I'll go right to you, okay? Lulu?
Is it next Monday?
Yeah, it's on Monday.
Can I come next one? Because Monday I'm booked. I can't come at 3:30. I have appointment
Any time between 3 and 5?
3 to 5.
Yeah.
Is it fixed time?
Yes.
Yeah?
Okay. 3 to 5.
While she's looking that up, shouldn't we really be talking to the department head?
Let me get Member Oka, because I know you have something to say.
I am very, very, very concerned about this, because if we continue to do what we just did, we're not only harming the public, we are harming the individuals who are losing productivity, if not money. And more importantly, we're not doing our jobs that we were appointed to do. We have to be credible. And right now, it doesn't look like we're being very credible to the public. The public out there thinks that we're not going to do anything. And that really concerns me, because based on what just happened with this vote, when is this going to go to where it should have gone, which is ethics? And then when is it going to be resolved? This has been since 2012, right? And here we are at the end of 2013, still no resolution. That's ridiculous. It's absolutely ridiculous.
Can we do that?
Yeah, so I guess my question would be, by sending it, if we send it directly to ethics, how would that help resolve the issues that we all see happening at the planning department, as opposed to
Point of order, Madam Chair, that question is not before us.
I'm sorry, I will comment on, if other people are allowed to comment on what is being done here, then I'm also going to comment on what is being done here.
The matter of sending to ethics has already been decided. It was.
Then why did you not interrupt Mr. Oka Member Oka when he was talking about being sent to ethics?
You could have done the same.
So, but you
I'm not allowed
to say.
Continue. Yeah, I'm going to allow you to continue. Just finish your what you want to say.
What I would like to say is that by sending it to the Education and Outreach Commission, Education and Outreach, I think that it gives us an opportunity to work with the planning department to try to get programs in place so that the public can get the information they need. There is nothing that would stop us after that, if we do not feel satisfied, in sending this to ethics. There's nothing that stops us from doing that. And this case, I feel badly for Michael, because I do think that he might have been, information might have been withheld in order for him, to not be heard in time. But that ship has sailed. I mean, unless he is interested in reappealing, right? I don't see the urgency in having to send it to ethics tonight. right? If we send to education and outreach, and we're able to get things in place so that future people are able to get information that they want, we can always come back to this case and say, you know what, it was not handled appropriately, and we are going to send it to ethics because there was there might have been an obvious delay. But I don't see that the rush and it having to go there this evening and how that's going to help anything.
Thank you. Lulu, would you be able to attend that meeting on Monday?
3 to 5, yes.
Thank you. Okay.
Lulu, I have a question for you. What's your title at planning?
I'm the operation manager, take care of the office.
Okay, and who do you report to?
My supervisor is Tom DeCento.
And his position?
CAO, CEO, something like that.
No, what's his title?
He's the Chief Administrative Officer or Assistant Director, something to that effect
Right.
at the Planning Department.
And I believe, Member Washburn, that was your suggestion, that a department head? Was that?
No, I think we need somebody who's involved in setting policies and procedures for the department to be involved in this.
That's the person we should invite to EOTC.
Right.
So
And that person may also be able to help the complainant finally get all of the records that he's been asking for. That should also be on the EOT agenda.
Member Pilpel?
I just want to be clear as we're moving through this, and I'll also say to Member Nee, I'm not speaking for the other members who voted against the motion, but I'm still very much on the fence here, and a motion to rescind would still be in order. So we're considering this very heavily. I would like to see Lulu on Monday and some combination of Mr. DeSanto. I don't necessarily need to see Mr. Ram, but is Ms. Lynn Sangen still with the department?
Who?
Is Joanne Lynn Sangen? Is she still with the
No,
department?
she's gone.
Who's the new person who's now the assistant?
Not
to-
yet.
Not yet, okay. Mr. Ionin?
Ionin, yes.
If we could see either him or Mr. DeSanto, if you could produce at least one of them in addition to you on Monday, that would make for a much more productive
I
discussion.
can't promise because I don't
But you're
have
going to
the-
try.
Yes.
Thank you.
From 3 to 5, right?
Yes.
Right here.
Yeah, is your meeting in this room?
Yes.
In this
Yes.
room?
And
Okay.
because of the timing and because all the parties are present, we're going to waive sending notice if we make a motion and do that. So if you have anything further, now's the time, and let's figure it out.
And can I ask a point of order? If we put out this invitation and only Lulu shows up, do we have the power, and is it appropriate for us at EOTC to refer it directly to ethics, or do we have to refer it back to the full
It would
task?
have
Has to come
it would
back
have
here.
to come back here.
And they have the right to, we are strongly suggesting they have the right to have a representative, but we are encouraging them. I'd like to get to this vote because we haven't done public comment. It's after 5:30. So is there a motion on the floor?
I move to send this matter to EOT and to have the person that Ms. Wong reports to attend, as well as her, and to, I guess that's fine, but I also just want to make sure you work with them to help this complainant get his records.
Second.
It's been moved and seconded. Is there public comment on this issue? If not, I'm going to close public comment. I'd like to take a roll call vote this time. Mr. Young?
On the motion, Member Nee.
Aye.
Nee, aye. Member Washburn.
Aye.
Washburn, aye. Member Pilpel.
Aye.
Pilpel, aye. Member Sims.
Aye.
Sims, aye. Member David.
Aye.
David, aye. Member Highland.
Aye.
Highland, aye. Member Oka.
Aye.
Oka, aye. Vice Chair Fisher.
Aye.
Fisher, aye. Chair Grant.
Aye.
Grant, aye. We have a vote of 10 to 0.
Okay.
9-2.
Victor, your vote counts for what, too?
Okay, yeah. So we will see you guys on Monday, and hopefully we can come to some sort of resolution. Michael, hopefully, will you be there? Yeah, come on.
Yes, I'll be there.
Thank you.
Can I say one thing? I don't know.
Yeah.
I've actually sent an email, I brought it with me today, to the Planning Commission, asking them not to decide this case until you all had a chance to decide yours, thinking that there might be mutual respect, and because information disclosure is integral to this process, it's written into the statutes of the land use entitlements in the California Environmental Quality Act. I've also sent emails to both planners saying it would be wrong for them to bring this to the commission without the information request being submitted, and directly to Sarah B. Jones here, thinking she is the top dog of environmental planning. And so on that note, I think she should be at that meeting on Monday. I think she would really benefit from it.
Okay.
That's my take. Thank you.
Perfect, thank you. All right,
I may be in communication with planning tomorrow on who and how, but we'll see you then. Thank you.
I'll leave that to you guys. Thank you very much for coming. Good night. I know it's 5:30. I'd like to go to public comment, Victor. And I'd like to...
Item number 5, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the Sunshine Ordinance Task Force jurisdiction, but not on today's agenda.
Perfect, thank you. And you have 3 minutes.
Well, thank you very much. And of course, stop the corporate rape of the public library. Don't give money to the Friends of the Library. Don't accept money from the Friends of the Library. This is a third part of my 3-part presentation, and I have distributed a flyer. I hope you've seen it. I was here for your consideration of equal access to the graphics facilities. At that time, Mr. David made some comments, and I just transcribed them directly from the recording. I did have multiple copies if anybody wants to see them. Let me quote just a few sentences from Mr. David's statement. Quote, not being a metaphysicist, I don't want to look into the soul of the Library Commission and what their desire is or not their desire. I don't want to speculate as to the reasons why they're not giving it being equal access. And later, quote, I find the libraries to be phenomenal, unquote. Why would Mr. David want to put a good face on this? It is true if you're just a child and you want to go down the library to read about Jack and the Beanstalk and the little engine that could, that's fine. Presumably when you become an adult, you want to know if your culture is being destroyed and individuals are ripping off the public institutions for millions of dollars. There's no guarantee that Mr. David is aware of the entire history of subversion of the public library, the building that we didn't need, the books that were dumped, the distortions and false promises. All that Mr. David needs to know is that over and over again, the public library has prevented access to the truth, blocked openness, and public participation. They were the major violator when I was chair of the Sunshine Ordinance Task Force. The point is that without access to the truth, not only are you preventing others from having an opinion, you're preventing yourself from having an opinion. Without access to the truth, there is no opinion at all, and you're just a slave dangling on the end of whatever manipulation they can perpetrate. There is a quotation that I've used many times, and it's a quotation from Hannah Arendt. Maybe some of you have seen me quote it before. If everyone always lies to you, the consequence is not that you believe the lies, but rather that nobody believes anything any longer. And a people that can no longer believe anything cannot make up its mind. It is deprived not only of its capacity to act, but also its capacity to think and to judge. And with such a people, you can then do anything you want. The point is that this is basic. You don't need to be a metaphysicist to recognize evil when you see it. This is a long tradition of abuse, of openness, of democracy, and it's time we can all recognize it. Thank you very much.
Thank you. Is there any more public comment?
Hi, I just want to say that every time I file an immediate disclosure request with the Arts Commission, it takes at least 15 hours. Say, for example, there's a meeting violation, and every single meeting, even from the street artist level all the way up to the full commission level, has problems with the way they run their meeting, they post the meeting, the timely posting of the minutes, all kind of problems. It's been going on for years. It's nothing new. Every time I attend a meeting, it might take 3 hours to speak, to have 3 minutes to speak under public comment. It doesn't post under public comment, then I spend another 3 hours waiting at the full commission to contest the minutes to ask that they be corrected. They're never corrected. So then I file an immediate disclosure request, and I wait. I wait for Lazar to come in, like the education and outreach meeting of last week. It was one picky detail. It was an immediate disclosure request that didn't even need to be filed in the first place. There were 8 points, simple questions that simply could have been answered. But Lazar keeps making the same mistakes over and over again, and my life will revolve around coming here to try to get him to read a request or answer it correctly or not provide a lot of extraneous, irrelevant information that has nothing to do with anything. And I really can't do that. I've been at this for a year. I never got any of the documents I requested, and he still continues to make the same mistakes. It's like an exercise in stupidity. Thank you.
Thank you. Is there any more public comment? Each have 3 minutes.
Thank you. If you could give me a 30-second warning, I'd appreciate it. I can't see the whole thing. I see 2:50. I have 3 minutes to start with. I'm Peter Wolf, Executive Director of Library Users Association. There are a number of things that have been brought up by previous speakers that I think are significant and worthwhile. Certainly the library has had a very long history of many violations. I don't recall a specific instance that the first speaker tonight refers to, but for somebody to throw out, I love the such and so department because of the presumably good experiences I've had there, it's completely irrelevant to that department's experience with Sunshine. And it just sounds to me like a slap in the face to the public for a member of this body to speak of essentially the irrelevancy of their experience with the department unless it's their experience with Sunshine-related issues. The immediately preceding speaker also talks about repeat violations. So I think one of the things that the Sunshine Task Force needs to do for the public and for itself is to organize some fairly basic history readily accessible of violations, orders of determination, and more specifically, what instances each section of the Sunshine Ordinance Task Force was ruled upon. So, for example, if I want to know what rulings have there been about violations of 67.15, there ought to be an easy way to go to a database or a table of some kind and see, oh, these 6 cases in the last year or whatever it is, multiple years, and here were the specifics about those cases which I can find out from the file, from the order of determination, and so on. I don't believe that exists, so that it's very difficult for members of the public and yourselves to understand what the history was of either similar complaints or similar violations that this body has ruled about. I think that would be a worthwhile project to set up a database like that. In terms of functioning for the public, I think the administrator's report, this agenda packet was not linked to online. I think the administrator's report is a helpful thing to have and to link to. Don't know why it wouldn't be linked to, and I think it would be useful to let people know where you are on the agenda so that they can know what's done or what's changed, what's been canceled, and so on, even if they don't come exactly at the very beginning of the meeting.
Thank you. Is there any more public comment on items not on today's agenda? If not, then I'm going to close public comment. I'd like to, Member Davis?
I would just like to clarify the record that, yes, I have had excellent experiences at the library, but it also happens to be that I voted in favor of the complainant in the case that Mr. Chafee is referring to, and so my personal experience did not get in the way of me taking the facts of the case as they were, and so I just would like to make sure that the public knows that I actually found in favor of the complainant in that situation, regardless of my personal experience with the library. Thank you.
Thank you. So I'll just take a vote. Do you guys want to take like a 10-minute break now, or do you want to go to the next item on the agenda?
Can I just ask, is Mr. Ng back? Okay.
Do you want, because I know he's going to do his presentation about records.
Could we maybe do the records thing and then take a break for a moment?
You want to sit down?
I'm sorry, I have a plan.
Yeah. If everyone is fine moving on, then maybe we'll do that and then come to...
Then take a brief break.
Take a break before we start doing the files. Mr. Young, can you read the next item on the agenda?
Item number 2, Proposed Sunshine Ordinance Task Force Records Retention Schedule.
Good evening, members. I'm Wilson Ng. On a more positive note, I'm going to talk about the records retention schedule and not a complaint. Just to reintroduce myself, I'm the records manager for the Clerk of the Board of Supervisors, and as you may recall, I presented to you all on November 6th with the Task Force Administrator's proposed updates to the records retention schedule, and this is essentially a continuation of that discussion that we had, this time with the hopes of getting your buy-in and blessing. And as most of you know, or at least now know, the City Admin Code 8.3 requires that a schedule for the systematic retention and destruction of records be in place for each department, inclusive of the Sunshine Ordinance Task Force. And just to recap the last meeting, there were a lot of opinions that were being expressed, and there was a lot of dialogue that happened, and I did take that into account. And the one thing that we all agreed on in the room was that the current schedule that was last updated in 2001 is clearly outdated, and at least we can all agree on that. So with that said, on behalf of the clerk's office, I want you guys to know that we took your comments and feedback very seriously, and we did include attached to your agendas, you'll see that I provided a current and proposed updated schedule along with any changes that happened to the current schedule that led up to the evolution of what's being proposed here today. A few things to note. On the proposed schedule, item number 8 regarding policy and procedures, based on the feedback that I received last meeting, I included an update for clarification that policy and procedures are retained permanent until superseded. Last version indicated that it was until superseded, and they may have caused some confusion and some debates, so I did include that point for clarification and also expanded the description a little bit. And any outdated policies, if anybody's concerned, can be disposed only if it's not detrimental or defeat any public purpose, as with any record in accordance to Admin Code Section 8.3. Comparing the current schedule with proposed updates, you'll see very clearly that the proposed retention durations are more extensive and categorically more in line with current retention practices, and hopefully the format that I provided is for you to easily compare the two. As just a friendly reminder and disclosure, I just want to emphasize that the schedule serves as a general guideline for your task force administrator for systematic retention and best practices. In accordance to Admin Code 67.29, I'm sorry. The index need not be in such detail as to identify files or records concerning a specific person, transaction, or other event. In other words, it doesn't have to be in excruciating detail, but it should clearly indicate where and how the records of that type are kept, which I believe I have done here. As with any record, in accordance to Admin Code 8.3, the department can elect to retain any record for longer periods as required based on what their actual purpose is. And it doesn't absolve any responsibility for the records holder to maintain records that are relevant to the public business. And And I believe the goal here is not to determine whether or not to dispose of a record, but to provide some criteria and just a systematic means and guidelines that'll strike a balance between efficient administration of our records and compliance of the delivery of those records. So with that said, I'd like to open the floor for any comments, feedback that you have to the revisions that I've made.
Okay. Member Powell?
So I weighed in considerably last month. Wilson and I have had an opportunity to meet and discuss several times on this in the intervening time. I think we made a few tweaks and clarified some things. I just wanted to walk through very briefly my understanding of the breadth of records of the task force, and we have not had a chance to go through all of that yet, but we shall in the fullness of time. But just in general, in our sort of body of records accumulated, my sense is that more than half of it is probably complaint-related files. Victor, can you just grab a sample complaint file? I mean, we see the stuff as part of the packet. That's how it ends up. That's a small complaint with not much stuff. Each complaint is in a file folder, and there are some number of volumes of that have accumulated over time. So that's a big chunk of our records. The next, I would think, somewhat smaller chunk is meeting-related stuff, which will include kind of extensive packets, but the agenda and the minutes, so it's things related to meetings. And then you've got sort of everything else, which is the bylaws, policies and procedures, general correspondence, that sort of thing. So that's how I sort of think of our records. And prior to this meeting, I was thinking about these different retention periods. Does it make sense for some to be 3 years, some 5 years? Should we standardize some of that? I'm actually somewhat glad everyone's sitting down. I'm somewhat persuaded by Mr. Warfield's testimony about past complaints. I was thinking about whether or not we need to save complaints forever and tending to think maybe we don't. At this point, I guess I'm somewhat persuaded for the moment. I think we do. We may want to refine that in the future. I'm not sure, that 50 years from now that complaints that are not sustained, if we really need to keep copies of all of that. Maybe, maybe not. Certainly complaints that are sustained, and particularly those where there's a referral made, where there's something of substance, I think we should keep some of that. Whether we need to keep all of the underlying documents, again, I don't know. And maybe when we get to the point of being able to digitize all of these things, we can save all of those because electronic storage is increasingly cheap and we don't need to keep all the paper files. But I'm not sure that we're completely there, but I think we're sort of evolving this concept of these various concepts of records management. So I'm prepared to recommend the schedule as it is now. We can certainly tweak that further over time, but I really want to appreciate Wilson's work on this and our continuing efforts on records retention here and elsewhere in the city. There are other things going on, but let's just leave it at that for the moment. Thank you.
Are there any more comments or questions from Member Washburn?
Yes, I'm looking at actually the document from October. So complaints here, it says that they're kept permanently on site.
Right.
So that's what we're going to do going forward.
Yes.
Okay.
So, that's consistent with what current practice is. And just for clarification, I do want to clarify what permanent means. In admin code terms, it means that it has to be permanently retained. We have to hold on to it forever. The retention schedule is agnostic to what type of format that it's retained in. Admin code requires that we have to either microfilm it or digitize it or some type of more compressed medium. Now, those things are contingent upon us having the appropriate infrastructure and resources for that, and we are having discussions about that. But as far as the current practice, we are retaining it permanently, and it's format agnostic at this point for the sake of this discussion.
Can I just clarify on that? At some point in the future, though, if we're not yet able to digitize all the stuff, I don't know how quickly we're getting to that, we might go with on-site retention of 3 or 5 years and off-site retention permanent. So we're not recommending that at this time, but we might not need to keep in the future all of the complaints on site from 20 years ago,
Right.
even if we're keeping them all. I mean, you know.
Right, I understand, yeah.
But we're not there yet. Sure. Okay.
Okay. Is there more comments or questions about your work that you've done and the proposed retention schedule? Member Washburn.
Just one more thing. I think it's important, you said that the categorization of lengths of time things are counter is agnostic to the way they're kept. And I think what's important to us, and I think important in general, is whatever permanent form the records end up being in, that it would be most desirable to have them be searchable in some way. And so I think, right, exactly. So I just wanted to mention that.
Yeah, administratively, I think we all agree that, I mean, a digital medium is the best as far as keyword searching and just efficiency and just more compressed medium, and that is the hope. And we are having discussions toward that direction.
Okay. Thank you. Okay, in this case, I'd like to know if anyone would like to make a motion regarding the proposed records retention schedule.
I'll move that we recommend adoption thereof. I don't think we're the final arbiter, so I think it's a motion to recommend. Does that make sense? Equal? Somebody? Motion to recommend recommend adoption of the proposed schedule.
Does that make sense, Attorney Lee?
I think that's an appropriate motion to adopt the schedule.
Okay. Do I have a second?
A second.
Okay. Is there public comment on this issue about records retention? And this proposed new schedule that he's suggesting.
I heard a mention of October, but I'm looking at proposed records retention dated November 27th. So I'm Peter Warfield, Library Users Association. The complaints, whether they are sustained or not, I think is not something that's described here separately, at least I'm not recalling it. I don't see that an unsustained complaint is any less valuable for the history than one that was sustained. If somebody tried to file a complaint that such and such an action violated such and such a section, and it was not sustained, I think that's just as useful for the body to know when it considers a similar complaint in future, or when the public considers making a complaint. I think it's just as valuable to know that as to know that that complaint in the past or some other complaint was sustained. I think that's just two sides of the same coin, so to speak. I'm a little bit troubled and a little bit not clear about item 8, which is on page 2 of 3, where there was a mention by your speaker and also in the text. If such and such records may be destroyed or otherwise disposed of, if their destruction or other disposition within a shorter length of time will not be detrimental to the city and county or defeat any public purpose. I don't know who is determining that. This is stated in the passive, and it's completely unclear who decides that. I think, not having studied this in advance of this meeting, I think that needs to be nailed down very clearly as to who determines and by what process is it determined. It certainly should be, I think, a public matter. I don't think that policies should be kept only until superseded. Policies may affect what happened or how it happened when people are researching previous minutes, previous agendas, previous complaints. So I think policies as guides to what you're doing and how you're doing it are just as important to keep as the complaints under which presumably those things were happening. reports on 10 and 11. I'm not sure why the 5 and 7 years. Again, I think those are excellent guides and, in a way, indices to what has happened and would be very useful along with the complaints, and they don't take up that much space. Thank you.
Is there any more public comment on this issue, on the proposed records retention schedule? If not, I'm going to close public comment. And Mr. Young, I'd like to take a vote on the motion.
On that motion, on the motion, Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpil?
Aye.
Pilpil, aye. Member Sims?
Aye.
Sims, aye. Member David?
Aye.
David, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Vice Chair Fisher?
Aye.
Fisher, aye. Chair Grant?
Aye.
Grant, aye. We have a vote of 9-0.
Okay, thank you so much for this. So we'll see you in 10 minutes. Okay, so we're going to take a 10-minute break and then come back to the next item on the agenda. You ready? I'd like to call this meeting back to order. Mr. Young, can you read the next item on the agenda, please?
Item number 9, file number 13035, complaint filed by James Chafee versus the Board of Supervisors Budget and Finance Committee for allegedly violating Government Code Section 54954.3A and Sunshine Ordinance Section 67.15A, public testimony by failing to provide an opportunity for public comment before taking action.
Okay. I wanted to see if the jurisdiction is accepted by both parties. Yeah? Yes? I just did the respondent. Okay, can I get a second?
Second.
Great, it's been moved and seconded about jurisdiction. Is there any public comment on this? Public comments closed. I will then declare the motion passed without objection. And let's move to the substance. I'd like to invite the complainant, Mr. Chafee, to come up, and you have 5 minutes to tell us about and make your case.
Yes, thank you very much. And of course, stop the hate, stop the ignorance. Don't give money to the Friends of the Library. Don't accept money from the Friends of the Library. Have you ever met a new person? I assume that you have. What is it that they always say? They always say the same thing. Oh, it's a pleasure to finally meet you. I've heard so much about you. As a matter of fact, I just met someone who said almost exactly that. Have you ever been in a situation where they didn't say that? It happened to me once. Only once, San Francisco Public Library. You find out it's a terrible, terrible thing. What we in our society think that we're entitled to do to people because we don't know who they are and they're not part of our circle is horrifying. We separate, it's very little acknowledged that we separate very strictly people who are on our power and influence level, and we look past and completely denigrate people who are not at the same power and influence level that we're at. I go to library commission meetings. In those days, I thought it wasn't necessary to say who you are, what you've donated, who you're friends with. It used to be a tradition in the old World War II that they'd come up to a group of Americans and say, okay, who among this group is Jewish? And the classical answer is, we're all Jewish. Because if you say, I'm not Jewish, you're giving permission to single out the people who are not willing to answer that question. Now, there's a principle in the law called stare decisis. When you were a kid, you didn't learn that term, but that's one of the first things you learn. What it means to a kid is you said Johnny could do it. And you go up to your parents or your teacher or whoever, and you say, can I go swimming? You said Johnny could do it. This principle of fairness is so entrenched in human consciousness, in human society, and the basis of fairness in our society, that we've distilled this into the principle of law called stare decisis, let the decision stand, which means that when you've granted privileges, rights, access to whatever, in a certain situation, you come and you say, I'm in that situation too, that principle applies to me. Now, it should be obvious what I'm referring to. Back in 2005, this body said that it is not appropriate to take 17 items or 7 items, or in this case 24 items, and have one period of public comment on those 17 items. Now, that should apply to me if it applied to the people in those days. You shouldn't be turning around and saying, well, obviously we can't rule that now because, who is this guy? No. If it applied to somebody then, it should apply to somebody now. May I know if the person who drafted this memorandum, well, actually, I don't need to know. There's a memorandum in front of us by somebody named Cecilia Lee. This memorandum says at one point that the complainant's allegations regarding a specific violation are slightly more opaque. That's not the business of the counsel for the task force to say that my allegations are opaque. If she needs an explanation, she can say that she needs an explanation, but not apply that to the complainant as an attribute of him. There is, as part of this memorandum, a suggestion that the board's practice in public hearings every year. Of course, that's not true. It's true about recent history. You shouldn't probably be telling each other jokes during this section because it creates the impression that you might be laughing at the speakers. Thank you very much.
Thank you. Is there anyone here to offer any support of Mr. Chafee? I was asking, and no one came forward. So I'd like to invite the respondent up. And you have 5 minutes to respond to this complaint.
Good evening, members. On behalf of the Office of the Clerk of the Board, I'm Wilson Ng, Records Manager, and I'm here to address the complaint from Mr. Chafee against the Board's Budget and Finance Committee, namely 13035. The complaint basically makes 2 allegations pertaining to the committee's June 19th budget meeting. Number 1, that the committee failed to provide opportunity for public comment, and number 2, the actions were taken without public comment. To address the first allegation, Mr. Chafee alleged violation to Government Code Section 54954.3a and Sunshine Ordinance 67.15a regarding public comment. Subdivision B of the Government Code and Subdivision C of the Sunshine Ordinance, respectively, both state that the policy body's authority to adopt reasonable regulations, including limiting the total number of amount of time allocated for public testimony on particular issues for each individual speaker. The Sunshine Ordinance also permits speakers to be heard once for up to 3 minutes, and time limits are required to be applied uniformly to the members of the public wishing to testify. So the Budget and Finance Committee conducted budget hearings over a 2-week period to consider proposed budgets and salaries for dozens of city departments. To help the mayor, controller, and public track the committee's discussions and its tentative plans, they announced its plans on the record during the discussion of each department's budget, all with the express reservation that the committee would make no actual decisions on any piece of the budget package until after hearing public comment on all the items. This is consistent with the board's longstanding practice in budget hearings every year for over a decade. The public was informed that public comment would occur on June 21st, 2013, and the June 19th, 2013 committee agenda had clearly disclosed the date and time of public comment and its full adherence to the government and admin code. On June 21st, public comment was accepted on the mayor's proposed budget, including the 2 library items, namely items 5 and 6. The committee did not take any actions until public comment was closed. To address the second allegations that actions were taken without public comment, the mayor's office submitted 26 pieces of supporting legislative as part of their budget submission, which altogether constitutes the proposed budget package and legislation for fiscal years 13-14 and 14-15. The items were effectively a single comprehensive budget package as submitted, as they were considered, and as they were acted. The items considered together in the committee were also considered in a single set of meetings at the Board of Supervisors on July 16th and the 23rd. The public library portion of the budget, including items 5 and 6, was discussed on the 19th and continued on June 21st for public comment and additional discussion. Other than continuing the item to June 21st, no other actions or decisions were made that day with regard to the library items by the committee. This is evidenced in the recordings and transcripts of all the proceedings. In addition, the Chair, Farrell, explicitly stated that voting on the items is contingent on hearing public comment and announced at various occasions during the budget-related meetings the date and time of public comment. Deputy City Attorney John Givner also advised the committee and public that no actions will be taken until after public comment on June 21st, and that preliminary discussions are to indicate to the Comptroller and the Mayor's office, who are tracking those matters, and to the public what the committee's tentative plan is moving forward. The committee didn't take any actions until after public comment was heard and disclosed. Public comment on the mayor's proposed budget was accepted on June 21st, including the two library items. So in conclusion, we believe that the complaint lacks merit, and there's no violation of the government code or sunshine ordinance as the complainant alleges. The committee informed the public in writing before open session and during the discussion of the two library items when the public comment would occur, and allowed for public comment prior to taking any action. The committee adopted reasonable regulations in accordance with sunshine ordinance, government code, longstanding practice, and consistent with what the city attorney's opinion is on this matter, to apply uniform policies in the interests of efficiently conducting business while also serving the public's opinion, while also considering the public's opinion before any action was taken. Since I do have some additional time on the clock, I do want to let the task force know that the memo that Mr. Chafee describes is actually from the city attorney's office, and they bring two legal determinations up to the task force for your consideration. The first question is, does the sunshine ordinance require that discussion or presentation regarding an agenda item and public comment regarding the same agenda item take place during the same meeting? And the answer for that is no, as I previously mentioned in government code as well as the sunshine ordinance or admin code. The second question is, does the sunshine ordinance specifically prohibit grouping agenda items for public comment? The answer for that is also no. There is no, the sunshine ordinance does not prohibit or address any grouping of agenda items. It looks like I'm right on time.
Yeah. Thank you very much. Is there anyone here that wants to offer any additional support for the respondent? If not, then I'd like to open it up to the task force members. Member Pelpel.
This is an interesting case, at least I find it to be. And first to Mr. Chafee, no, we were not telling jokes about it. I at least was very much listening and was rather moved by your opening remarks. I would note first the 2005 letter that's in the packet, page 285, Exhibit E1 from Mr. Chafee. Apparently, that came out of a meeting held in this very room, March 22nd, 2005, when Victor Young was clerking the task force. It's a small world, after all. Yeah. Anyway, so yes, this issue of grouping of items and sufficient opportunity for public comment has come before us. It's instructive. I'm not sure that it's dispositive, but it is certainly instructive, and it's very helpful to me. Although I'm sort of dancing around a couple of different things here. To Mr. Ng's comment at the end about the two considerations in the city attorney's memo, I would agree that the Sunshine Ordinance does not require public comment, does not specifically require public comment on an agenda item at a meeting during which action is taken, but I think it's only in from my perspective, limited circumstances where a public hearing on an item would be closed and not reopened at a subsequent meeting when action is taken on an item. So I do see and read narrowly the requirement that public comment be taken on every agenda item at a public meeting at which that item is to be heard. And as to the second item, does the Sunshine Ordinance specifically prohibit grouping of agenda items? No, that's correct. It does not. However, I think what we've interpreted before and what we may be interpreting now is whether 67.15C about a policy body adopting reasonable regulations to ensure that the intent of subdivisions A and B are carried out has allowed for enough time for public comment given the nature and complexity of the item, and if you are grouping multiple items in one opportunity for public comment, 2 minutes or even 3 minutes may not be sufficient depending on the complexity of the matter. So if I can go to a couple of quick questions. I don't know if Mr. Ng knows the specifics of the particular Budget and Finance Committee meeting. Again, our friend Mr. Young may know more of that because he was probably there. The items that Mr. Chafee was concerned about related to the library came up for discussion and presentation at the meeting of June 19th. Mr. Ng, can you comment on that?
I'm sorry, can you repeat the question one more time?
On June 21st, the items related to the library were on the agenda and came up for discussion, yes?
I don't have the 21st agenda in front of me.
I think you do. No, on the 19th is what I was asking about first.
Oh, the 19th, then yes.
Pages 274, 275 of our packet, they're on the agenda?
Yes.
Okay, and it refers to public comment on the 21st. When did they come up for action? Was that on the 21st?
On the 21st, yes.
Okay, and they were acted on the 21st, is that correct?
I believe so, yes.
It appears that way from our
Yes.
record. And when was the public comment for that item heard?
On that same day.
Okay.
On the 21st.
Okay. So as to that public comment section, is that the public comment, the general item on the 21st, public comment for the annual budget for 2013-14 and 2014-15 for all departments?
Are you asking about the disclosure that was?
I'm asking about how that public comment period was handled. Do you know?
Unfortunately, I wouldn't be able, I don't know.
Okay. Mr. Chafee, do you want to speak to that for a moment? Were you at that subject hearing?
Of course, I was not there at the 21st, no.
You were not there at the 21st?
Yes.
Okay. Is it your understanding that all of the public comment was taken under that item on the 21st?
The public comment was taken on the entire agenda on the 21st.
As one opportunity for public comment?
Yes.
Okay. Is it, I mean, I'm leaning in this way, but I want to understand your contention. Is it your view that, Mr. Chafee, that public comment opportunity on the 21st was insufficient for members of the public to comment on both the entire budget of the city broadly and the presumably 26 pieces of trailer legislation, all within, I don't know, 2 or 3 minutes? Is that your contention?
2 minutes, yes, that absolutely is my contention. Let me be a little specific about the traditional way this is handled. For many, many years, when the budget came up, they handled each department separately. And if you had a comment about the police department came up, the police chief spoke, somebody from the police commission spoke, they called for public comment, and if you were concerned about the police budget, you had a chance while the police chief was there, while the police commissioner was there. then they went on to the fire department or whatever. That was the case for many years. I'm not quite sure when they changed that. I remember that someone brought a complaint before this body when they did. May have been Monet Shaw, I'm not sure. In any case, this committee decided that that was appropriate. I thought that that was shocking because by the time you take public comment, the police chief's gone, the fire chief's gone, they're all gone. And one of the provisions of the Sunshine Ordinance is that you're allowed to comment before or during the consideration of the item. And in this case, they told the library, you won't have to come back, which makes the public comment the anachronism, what word am I looking for?
Superfluous is the word.
Superfluous. No, that's not. It'll come to me. In any case, it makes it irrelevant that you're going to make public comment 2 days later after everybody really was focused on the issue has gone with the wind, so to speak. Thank you.
Member David, can I ask, or did you have a question?
I'll come back.
Okay, Member David?
Is it not the case that the public comment is for the budget subcommittee and not for the fire department or the police department or the libraries, as the case may be? It's public comment to inform the members, the supervisors that are a part of the budget subcommittee. So if the supervisor subcommittee is there hearing the public comment, I don't see why the police chief needs to be there. There's a police commission that you can go and speak about to the police, but if we're talking about the budget subcommittee hearing, I'm a little bit confused as to why anyone besides the supervisors who make up the budget subcommittee would need to be there to hear what the public comment.
Is that a rhetorical question?
If people want to respond to that, I'm just...
Are you asking either them or Mr. Chafe? You're just putting it out?
Throwing it out there. People are welcome to comment on it.
So perhaps, Mr. Ng, you might be able to answer that?
I don't have a response to that particular question, but I do have a couple points of clarification to make based on some of the previous comments that were made. I just got confirmation that on the 21st that every title and public comment was accepted on that date. And as far as Mr. Chafee's allegation that the committee advised the public not to come back, I didn't see any of that information on the transcripts or anything like that.
I'm not sure that that's what he said. I think what he said is that the committee advised the department head that there were no issues with that department, and that department did not need to return the following week. Am I correctly summarizing?
Yes.
Okay, thank you for that. That's all. But as far as the complaint from 2005 regarding the unconventional bundling of items, I think the context of the word bundling was not really definitively defined previously, because the context of that previous complaint was in regard to environmental findings of Hunters Point Shipyard. And what we're here talking about today is really essentially the budget package, which has historically always been one essential piece. Regardless of how many items are in it, comprehensively, it is the budget. And it's submitted as one, considered as one, acted on as one, passed on to the Board of Supervisors as one. And if we're going to define bundling as anything and everything that has subcategories within it, that could potentially be indefinite, and that could be an ongoing discussion, and you could be opening a can of worms here. That's what I'm saying.
Member Washburn?
I'm just trying to visualize what happened on the 19th and the 21st. So we're talking about the Budget Committee of the Board of Supervisors, and the members of the public, that is where they are able to speak with supervisors, not at the full meeting. So on the 19th, there was an agenda, itemized agenda, and there were items for the police department, fire department. There were two for the library, dealing with quite different issues, and so on and so forth. So on the 19th, the department heads were there to discuss their particular budgets with the committee members.
Right.
And so this happened on the 19th, and the public were supposed to come back on the 21st and make their comments.
Right.
Okay, so on the 19th, the whole budget, line item by line item, was reviewed. Department heads chimed in, supervisors asked them questions. Then on the 21st, the department heads didn't come back because they've already had their say.
Right.
And so the supervisors were, I guess, possibly making some changes in the budget based on what the department had said, and then they were going to make a final vote to send it on to the full board.
Right.
And the members of the public were given some time at the end of that meeting before the supervisors voted.
Right.
Or the beginning, maybe.
The 21st.
So 2 minutes each, up to 2 minutes each, to talk about any item at all on the agenda. So somebody would talk about police, then library, then it was all the jumble. And then the supervisors voted to send something on to the full board. So that's what happened.
That's correct.
Okay. I guess I'm having a problem with that because I can see where it would be efficient for the Board of for this committee to not have the public commenting all along the way on each of those agenda items. So you just kind of put them off until the end of the process, and on a different day when the department heads aren't there. Okay. But I think the Sunshine Ordinance doesn't say anything about the public comment happening on a different day, but the public is supposed to be able to comment on items on the agenda, each one of them. I mean, that is how we run our meetings, how I think most commissions run their meetings, probably how Board of Supervisors committees run their meetings. You know, you don't go through the whole agenda and then the public waits till the very end when the remarks don't have the impact that they do when the supervisors are thinking about the issue. So I'm thinking off the top, this is off the top of my head, I'm trying to understand what really happened, what the intent of the ordinance might be, and so I'm anxious to hear what other members have to say about this.
Member Pilpel?
A lot of things running through my head. So there are requirements in the charter and the admin code about the budget process, budget hearings, public comment, that sort of thing. And then there's sort of the practice of the board and the Budget and Finance Committee, which has changed over the years. For a while, as Mr. Chafee indicated, public comment was taken on each department as it came up. And I like that very much myself because, you know, when you had something to say about the police budget, you said it, the chief was there. In particular, the analyst from the budget analyst's office who had reviewed the police budget was there and listening. And if the committee directed a question and said, well, what is that about our purchase of ammunition and why is that going up from 500 to 529,000 next year, please review that and come back next week and tell us about it. That's when those kinds of comments are relevant. At some point, the practice shifted to having all of the public comment at one time. For a while it was on a Saturday, either Saturday afternoon or Saturday morning or Saturday all day. Then for the last few years it's been like on a Friday. The departments are not heard all on a single day, by the way. They're spread over 3 different days, usually. These practices have changed over time, more for the efficiency of the members of the Board of Supervisors than for the convenience of the public. And I think that that has actually been to the detriment of the budget process, which has sort of been reduced to an exercise. And I have sat through much of that exercise from time to time. I've sat in this building till 3 or 4 in the morning when they're on recess. There are a lot of stories of all of that. But bottom line is, when, as I believe was the case this year, and I did not follow the process closely this year, if the opportunity for public comment at the beginning of the meeting of Friday, June 21st, was a 2-minute opportunity for comment on the entire budget and all of the 26 pieces of trailer legislation. And I should note that trailer legislation is still by ordinance primarily, except for a couple of budgets that are approved by resolution of separate agencies like TIDA and redevelopment. But those separate pieces of legislation by ordinance are subject to the single subject rule, which means that they cannot go beyond that particular subject. And so public comment on those items, in my view, should not be grouped, and you should have a greater opportunity to comment, whether it's on the particulars of the library or whatever it was, the fire department EMS fee, or the whatever, all the various pieces of trailer legislation that amend codes to change requirements. So I am generally persuaded that insufficient time was allocated for public comment, and that the grouping of items into a single opportunity for comment, particularly on a different day from when the item was originally heard, is not a good course of action, and I am inclined to find a violation and recommend that there be a different method by which public comment is taken at Budget and Finance Committee meetings in the future. I probably said too much, but there you go.
Member Oka?
Dovetailing on Member Pilpel's comment, Mr. Casey, will you come up, please?
Of course, absolutely. Excuse me.
Having attended many Budget and Finance Committee meetings in the past, I would have wanted my comments to be heard by the department heads that were in attendance. Is that your assertion, that is your concern, that you were not able to make your public comment while the department heads were there to hear your concern?
That's the way I characterized it, but I don't think that's really of the essence. That's kind of a characterization which brings in a lot of issues, which is that, of course, the supervisors, the budget analysts, their own staff, and the department heads and the department heads' staff are all there, and there's a back and forth. Oh, what about the blankety blank? What about the blankety bank? And they discuss those issues. And if you've not seen that process, that's the kind of whole dynamic that's taking place. And that's what you want to say, they're wasting money here, they're wasting money there, and it becomes part of that discussion. That's the point.
It's my understanding, Mr. N, that the department heads are not required to respond to the members of the public's comments?
I don't believe they are. The reason for that is because a public comment is really directed to the committee and not specifically directed to the department. And the decision maker is ultimately the committee members. And considering that no decisions were definitively made during the 19th meeting, I believe that the hearing public comment on the 21st before any decisions were made, with or without the department, because the department isn't really deciding. They're the ones submitting the items onto the budget. The ultimate decision makers that if the public wants to influence and have impact, they're speaking to the committee and not the department. So that's where I'm kind of coming from.
Member Nee?
Mr. Ng,
Right.
if I'm a member of the public, and I have concerns about allocations in a whole bunch of different departments, you're telling me that 2 minutes is adequate time to address all those concerns? If I got, let's say there are 6 departments whose budgets I have serious questions about, you're telling me that 2 minutes is ample time to go into the details about all 6 of those department budgets?
I'm not telling you anything, but then the Sunshine Ordinance, it's explicitly defined in there. It does impose a maximum duration of time. It doesn't impose a minimum duration of time, and if the issue that at hand right now is to determine whether there has been any violation of the Sunshine Ordinance, what I'm telling you is the answer is no. So.
Member David, sorry.
So I'm reading the complaint, and the complaint says that it was violating government code and Sunshine Ordinance number for public testimony by failing to provide an opportunity for public comment before taking action. Was public comment taken before action was taken?
Absolutely.
Thank you.
Member Popo?
I don't want to go on too much longer because I'm probably going to make a motion if no one else does. I think ultimately that we should find a violation and send this to EOT, and we'll have a hearing on this next year and talk about their practice prior to the next round of budget. Yes, public comment was taken, but I think what we're doing is interpreting, again, 67.15C and 54954.3B about whether the regulations that were adopted by the body at the particular hearing were reasonable under the particular facts and circumstances at the time. And my belief is that they were not, and that this is a practice that we should examine more closely and see if changes can be made, because I think that the public comment and public involvement in the budget process has been marginalized to the point where it's taken, but it's taken not with the intent that it's going to go anywhere. It's just another exercise in hearing people for 2 minutes and then next speaker, and it's not having any meaningful impact, and it should have a greater impact, which would be helped by a different timing process and an opportunity for comment. So unless there's anyone else, I'm happy to make a motion.
Well, I'd love to talk about it, but Member Sims, you can go first.
Oh, well, I find it interesting in the fact that the reason that they're being lumped together is because they contain the same subject as budget and finance. Then if we allow them to do it in the same process they've been doing it for the past couple of years, we're essentially saying that as long as the subject matter is consistent, you can take public comment en masse as long as you don't make the decision until after all public comment has been had. So essentially, since all of our subject matters are violations of the Sunshine Ordinance Task Force, we could go through here and hear every case and then say at the end, not take a decision and not take a vote, and then at the end say, all right, now we're going to have public comment. You only get 3 minutes, and if you had a public comment about, this or that or whatever, I'm sorry. And I just think that is similar. So unfortunately, I see the efficiency that the trust office is trying to, enact I see how it will and maybe will get long, but I guess I don't really have any answers to how you can fix that except rewrite the Sunshine Ordinance. I mean, I'm just sorry.
That was kind of what my question was, because the complaint, I agree that the public is not being able to be heard on particular issues on the budget, like within each department. And it doesn't seem like it made sense the old way, if you could talk. And I understand that you're talking to the committee, but I still think that the public's voice could be heard on, because there's specific things they want to speak to. So lumping them all at the end doesn't make sense. That being said, the complaint is that there was no public comment. And so there was, before action was taken, and the action was taken after they spoke. So I don't see where there would be a violation, because they are within kind of the legalities of 2 to 3 minutes. And I understand what you're saying, but for our purposes, I do believe that EOT, because I do think a recommendation is definitely in order. I just don't know how we would go about doing that, because is there a definitive violation? And I just need someone to show me that definitive violation based on the complaint that he asked that there was no public comment allowed before action was taken. So
go ahead.
Oh,
yeah.
I think the violation is of 67.15C.
Yep.
A policy body may adopt reasonable regulations to ensure that the intent of subdivisions A and B, which pertain to meaningful public testimony, are carried out. So we're saying what they were doing wasn't reasonable.
Got it.
They were diluting public comment, marginalizing it, to use Member Sims' term. And so that's it.
Exactly. How long have you guys been doing, well, you know too, the meetings in this forum? Is it a couple years? Were you guys changed, do you know, the form?
No, actually, I've been employed here since April.
Okay, great.
And these
Congratulations.
And I am a messenger in a sense.
Okay. I just didn't know. Do you know if, like, for the past couple of meetings?
I probably have the most
Victor has been here for
seniority
quite a
in this.
while.
Do you know? Like,
I would say it's been the last, 5 to 10 years that we've been in sort of this particular mode. I think the last time there was a big recession and there were a lot of budget cuts, it was like there are going to be a lot of people coming, so how can we handle them efficiently? The last year or two, I think the budgets have been a lot better. There have been fewer cuts. I'm not saying there's been no public comment. There has been, but they moved into this particular mode of how public comment was taken, and that's sort of the current practice. Victor, am I way off on this?
I really don't want to comment on previous chairs, but the process has changed depending on who the chairperson is.
Yeah, the chair as advised by whoever their key staff person.
so each year it could just be, it changes based upon who's there. Okay, and their
change by that much, but
interpretation.
it sort of gets tweaked a little bit every cycle.
Okay.
And I was just going to say, I'm sorry, that I do think there is some accommodations and streamlining that can be done through the clerk's office to make kind of the process that we think is the right one, or at least many members of the task force are have commented is the right one, to be a workable process. It will be longer, there's no doubt, but to do the right things, sometimes you just have to deal with that. So I think if Mr. Chaffee comes here later on and has another complaint about something else in their attempt to structure the process better and within our findings, then we'll take that up. But until then, I don't know how I feel.
Okay, perfect.
So just to follow up, and then I'm happy to make a motion.
Great.
I didn't watch or go to the meeting today, but according to today's agenda at Budget and Finance, there were 18 items. 16 of which were legislation and 2 of which were hearings. I suspect that each of those items were called separately, and there was a separate opportunity for public comment of up to 2 or 3 minutes as appropriate on those items, and they were not grouped and said, okay, you've got 2 or 3 minutes to talk about all of the following things and then we'll act on it. They're all very different, lease amendments, grant approvals, whatnot, and one could argue in the same way, and one, I think, reasonably should, that each of these pieces of trailer legislation are important to various communities, and to suggest that they're all lumped together and it's all part of the big budget, you know, I think does a disservice to the public. And it's kind of like, if we're going to have public comment, which I think we are, we should try to make it meaningful. And if we're not making it meaningful, then we're not doing our job as a city, and I think we can help improve that. So I guess I've waited long enough, so why don't I move to
I don't believe did I give you the last opportunity to speak? No. So I'd like to invite you up. You have 3 minutes to give a respond or concluding remarks.
Okay.
You have 3 minutes.
Okay. So I don't have too much else to add, aside from what's already been said. But, I mean, I guess what I wanted to ask the task force to do is put yourself in the shoes of, if you were on the committee, how exactly would that process be handled? Now, and how, if public comment was taken on the 19th, and what would the context of that public comment be? And how much additional value would that add with the department sitting there if no decision was being made at that time anyway? And none of those matters were going to be acted on during that day anyway. And the only action that was taken on the 19th was that the matter was continued. And so you would basically be going up to the podium to comment on whether or not something should be continued or not. Whether that adds value or not, I mean, I question that. So, I mean, that's pretty much it.
Okay. I just want to say one thing. I just think that the public, you know, they don't get an opportunity a lot of times to speak before department heads and things like that. So it is an opportunity for them to be heard. And I understand it's the committee that will make that final decision. But I also think that it's not, it's kind of like a matter, I don't know, of fairness or something, but to at least have the opportunity to be heard by a specific department that they might have a specific concern with. Whether there's any action or anything at that time is kind of not the point. It's just giving the opportunity for them to be heard. And then at the end, it might make it, you know, it might sway someone, it might not, I don't know. But.
Yeah, and I'm seeing 2 issues. Well, I mean, just to weed it out a little bit further, I'm seeing that there's one side where it's whether we're in violation of that complaint based on Sunshine Ordinance, based on government code. And I think I've clearly, I've repeatedly said, no, we're not in clear violation. Now there's the other side of the argument where it's like how you would like the process to be, and I mean, how we can engage the public and make other efforts and provide recommendations on how to improve that process. And that, I think that should be, I think those 2 things should be differentiated as separate, motions or topics.
I guess what Member Washburn was saying, and I hear you too, but when you go to 6715 and you go to 6715A, and it's every agenda for regular meeting shall provide an opportunity for members of the public to directly address a policy body. And I know it's the committee, but it's kind of murky because I think that they should still be able to talk to the specific budget, the department that's there. I mean, that's the kind of way I see it. And it's twofold, because I was the one that was saying that, you know what's the complaint? He's saying that there was no public comment allowed before a decision was made. And yes, there was. So if we were to just be black and white, you did, fulfill that. But when you really look at it and look at what the public is trying to get out of it, it's kind of like they didn't get anything out of it. So it's not like this give-take relationship. I mean, that's the way I see it. I don't know if someone wants to respond about it, but I kind of am looking at it like that. So remember Washburn, because that's what I was asking. I was like, what would we argue? What is our violation? What is your violation here? So when, 6715C, and you go up to A and B, I do see some violations there. I believe. It's kind of, yeah, I'm kind of going back and forth, so. Oh, are you finished? I'm sorry. Okay, thank you. Mr. Chafee, you two have 3 minutes.
Actually, I noticed that you didn't run the clock while he was talking. I hope you won't run the clock while I'm
I
talking.
was running his clock. I had reset it after you finished.
Okay, yeah, I don't believe so, but yeah, let's move on, since I've got 3 minutes. It's true that you're addressing the committee. You know, there was a time when Quentin Kopp and Dianne Feinstein and any number of people were members of the Board of Supervisors, and if you made a point, they would turn to that department head and say, what about that point that citizen that made? You know, now, of course, Mark Farrell and Eric Marr and John Avalos are not going to do that, but that's a political problem. The fact is that it's on their mind what's going on. Now, in fact, the change, which I didn't research it, I think it must have happened in 2007, 2008, where they stopped hearing the departments and the public comment together. The fact is that this is the first year, that's bad enough, but this is the first year they've decided that changes of the fines policy or changes in the gift fund or situations involving the botanical garden waiving fees or the health code patient rates, that these would be subsumed under a budget. Those were always separate items that needed to be considered separately. This is the first year they've decided that those things are now part of a budget submission. That was never true before. The fact is that when these things are approved, they're approved because of the consideration that's taken place. Now, what did we have at that meeting? We had Mark Farrell finish his discussion with the department head, finish his discussion with the budget analyst, and say, okay, we'll approve those items. Eric Marr said yes. John Avalos said yes. Okay, stand approved. And he brought the gavel down. And I sat there like a fool. Instead of with my poker face, I made this astounded look like, ah. And the city attorney, deputy city attorney, stood up and said, well, I should remind you that that's just preliminary. You know, that's not a final thing. And Mark Farrell said, oh, thank you for reminding us. You know, if he wanted to be legal, what he would have done is said, oh, yeah, we need to rescind that vote. He didn't rescind it. You know, he just said, well, you know, actually he didn't say anything. The point is that it was a de facto action, you know, just because they duplicated it later and they acted on it because they never talked about it again, never had the department back again to consider what the public might have said. Thank you very much.
Thank you. So do I have a motion?
Sure. So I will make a motion.
After.
Find a violation of Section 67.15C and Brown Act, California Government Code, Section 54954.3B. Finding that the regulations related to the time allocation for public testimony at the subject meeting and the manner of taking public comment on the budget and trailer legislation was not reasonable under the circumstances.
I second the motion.
Thank you. Is there some public comment on this item?
Touche.
Is there public comment?
Yeah. I heard about this kind of thing. People told me stories. Don't even bother to go to these meetings because you're going to hang around all day and you're going to be in this long line of people and you got 2 minutes, and how can you possibly say what you want? And that's why a lot of people don't go. Bye.
Thank you. Is there any more public comment on this particular item?
Peter Warfield, Library Users Association. I'm very glad to hear many of the comments that have been made by members of this body, and I think you're politely right on. The fact is that the supervisors have more and more trashed public comment. As one of your members said, a comparable thing would not just be hearing all of the cases and then taking public comment and taking no public comment, and then at the end of the meeting taking public comment. The comparable thing would be for you to say, well, let's meet in 2 days and have the public comment then, when it's even more beyond your understanding and recollection and so on. And above all, the wherewithal to make use of the public comment to say to a commission member or a department head, well, what about what that member of the public said about your priorities or about wasting money on this or not enough money on that? But even stronger, as Mr. Chafee has said, there was a vote, and I was there. There was a vote by the committee. It's on the top of your page 270 and Mr. Chafee's complaint, page 2. They had a vote and unanimously passed those items. And only because of Mr. Chafee's front row, and hardly anybody else was in the room, exclamation by sign language, did the city attorney deputy then get up and say, oh, well, that's just preliminary. But that didn't change what they did. They did not rescind their vote. So they took an action. Now, in my opinion, even if they hadn't taken an action to tell department heads, you don't have to come back, well, that's as though all the people you might ask questions back and forth as you've just done now and as you often do, and rightly, there'd be no opportunity for them to ask the head of the library department, well, what about that and what about this and so on. Now, I don't know what the term trailing legislation means, but a budget, in my view, is what will the supervisors allocate, approve to give a department to spend. The legislation in question was completely different. It had to do with fees to the public, which the library wanted approval for. And the other item was the creation of a gift fund. Completely nothing to do with a budget. And in the mayor's submission, I see that it's listed separately as separate legislation. Then the agenda for June 21st talked about budget. Did not mention public comment in its general description for additional agenda items. And so I think there were clear violations both at the meeting with regard to failing to allow proper public comment because a decision was made in various ways, and the agenda for the 21st meeting did not indicate what the purpose of the meeting was.
Thank you.
Thank you.
Is there any more public comment? Okay. Mr. Young, can we take a vote at this time?
On that motion, Member Nee.
Aye.
Nee, aye. Member Washburn.
Aye.
Washburn, aye. Member Pilpel.
Aye.
Pilpel, aye. Member Sims.
Aye.
Sims, aye. Member David.
No.
David, no. Member Highland.
Aye.
Highland, aye. Member Oka.
Aye.
Oka, aye. Vice Chair Fisher.
Aye.
Fisher, aye. Chair Grant.
Aye.
Grant, aye. We have a vote of 8-1.
Great.
EOT, rock and roll.
Yeah. So I'd like this to go to EOT, Educational Outreach and Training, to work with the department to make some suggestions for things that are more transparent for the public and an opportunity for them to comment.
And why don't we do that in January or February? I don't know if the board is going to change the committee assignments, but I think it would be best to work with the new, whoever the chair is of Budget and Finance, if it's Chair Mark Farrell or whoever, as relates to the process for...
And can we explicitly invite that person?
That person and their key staff person on.
So when
and Mr. Chafee, absolutely, if you'd like to come at that time. Let's see what we can do on this.
So when will the new...
Usually mid-January. Yeah.
So should we plan for the February meeting?
Probably. Well, January or February, but probably February.
Just so you can have it
okay.
in your
Fair
mind,
enough.
your agenda.
We'll work on it. Thank you very much.
Great. Thank you very much. Thanks for coming. Can we go to the next item on the agenda, please? Oh, okay. So let's talk about these approval of minutes. Is that what you're going to?
Yes.
Okay. So we have items 10 through 18, the approval of minutes. So let's just go through.
Madam Chair.
Item number 10.
Madam Chair, I would like to move continuance of items 10 through 18. If there is a second, I will explain why.
I'll second, and we can discuss. Sure.
We have a couple of problems. Number one, none of the minutes reflected contains any of the fixes that were previously or currently recommended. Number two, I and perhaps other members of the task force have submitted extensive suggestions for edits to those minutes. I specifically requested that the suggested edits, that my suggested edits be included in the information packet with this meeting. They have not been. And I think that that does a disservice to the task force members. It does a disservice to members of the public. To thrust these in front of our eyeballs at the last minute, right before the minutes are to be acted upon, does a disservice. And the task force members and the public have the right to see, to peruse those, to see the edits, the suggested edits, with ample time to look at them before action is taken.
So, let me ask you a quick question. So are the edits, I haven't seen your edit, but are they substantive? Yeah, are they substantive or are these grammatical? What are the edits?
Some are substantive, some are grammatical or syntactical.
Mm-hmm.
There are some spelling errors. I mean, every single set of minutes here are rife with errors.
Okay.
And the fact that we are not allowed to see suggested edits, with ample time, and I did submit them in ample time for them to be included in the information packet, and they're not there.
So let me ask Mr. Young. So when, Member Nee submits his suggested edits, if it's substantive, do you take those into consideration and then implement them into, since you're responsible for the minutes, implement them into the minutes already? So when we get them, you've implemented people's suggestions already. So by the time we get them, they're already a part of it. Or is it that you haven't, you're doing a separate document with his edits, so then we can look at it? Which I don't think, if there's a spelling error and he points it out, you can just do that on your own. We don't need to see that. But if it was substantive things, changes, you can say that these have been updated with his changes. How does that process work for you?
It is my intention to take substantive changes and include it into the draft minutes.
Okay.
Concerning spelling errors and so forth, I would make those corrections.
Okay.
Based on suggested edits.
Okay. So what Mr. Nee's talking about, so you took into consideration his edits, or you just haven't a chance to do those?
I have not performed that for this set of minutes.
Got it. Okay. So you were just backlogged, or?
I wasn't aware of it until today. I was informed that I should be including those.
That you should update the minutes based upon, integrate, that's, okay, so that's something that you want to do. Okay. Let me get Member Washburn first, and then we'll go down the line.
previously, we would have Word versions of the minutes so that we could make our edits and track changes and submit them. And I did that for many of these minutes, some of the early ones there. And then I reviewed the minutes from last month, and I have lots of issues with them, but, you know, it's just, there's no easy way for me to get these to you without, you know, a lot of work on my part, which I'll do, but it would be easier if I had a Word copy that I could use track changes.
Just so he understands and we all understand. So what you guys, I don't know what I'm doing. What you guys are asking is that you want to have a working copy so we can track changes, email it to him so that when we come to this meeting, your changes have been implemented in it at that time, and so then you're comfortable being able to approve it, because at that time, you will know that the changes that you've done have already been implemented. And right now, they have not been, because is that, so...
Well, I think we were doing that before, weren't we? We were getting copies in Word.
That's correct.
Yeah, and I was going through and, you know, sending my...
Yeah, and you'd send them, and then Andrea would go in and then make those changes.
So I'm thinking some of those early minutes listed here maybe have been edited, taking into account our suggestions. So, but I don't know. I have no idea.
But Mr. Nee, you're saying that your changes have not been implemented.
That's
you can
correct.
Look and see. Okay.
That's correct.
But you now have Mr. Nee's documents, so
Yes, I do.
you can make those changes at your by the next meeting.
Yes, I can do that. And in regards to submittal of Word documents of draft minutes, I can do that after they are created for member edits. However, I just want to state that I will make substantive changes where I agree with that there are errors in the minutes. However, grammatical issues, I reserve the right to make those judgment calls.
Yes, and I agree with you on that. Mr. Pilpel.
Okay, so I think we've done things a bit differently from time to time, and we're trying to figure out how to
Best way.
clear this up going forward.
And the best way, because to help Victor with this process in a way that helps us but helps him and doesn't force like all this other stuff on. So if we're giving him this information and he can turn around, that's good.
And we want to get caught up with minutes and stay caught up and not have 100 pages of minutes, et cetera, et cetera.
Yeah.
Okay, so I actually have, since I didn't get this before, I did one set of minutes, which is April. Here it is, some hand corrections. I had done hand corrections last time for the March set, but I don't see those reflected in this latest version. So I suspect that you probably have some stuff from me, emailed stuff from Member Nee, maybe from others. So if we can give you the time to get caught up, and in the future, once draft minutes are created or edited, if they can be circulated to the members as a Word doc, and if we can get them back to you with those kind of track changes so that you can turn them around, and so the packet then reflects the latest and greatest version, and if we have stylistic, editorial, whatever changes to make between the packet and the meeting, that we can do that, and then you'll have a final version that we approve at the meeting.
Mm-hmm.
Is that a working process that makes sense, knowing that that's going to take time and to catch up and then to stay caught up with that? I don't
Moving
want that too much
forward,
time on minutes, but I want to get it right.
Yeah,
This process sounds like it is workable.
For you? Okay. That's it. Just so from this point on, particularly, like
And Member Nee, does that
starting
make
out,
sense to you as well? And Member
And then we
Marsh?
go back and correct all the other stuff, but as what's workable for you. But for the future, maybe that might make it easier if everyone. And so you have to tell us, because you know your workload and you know what works for you and what's doable and what's not, because you don't want to say yes, I'll do it, and then it can't happen. So if that works for you, that like from now on, you can the minutes like from this meeting, you can send us a Word document, and then people can make their changes, and then do you see what I'm saying?
Yes, that is workable. That sounds workable, and
Okay. And then
Mr. Young, Are the minutes done in Word?
Yes, they are created in a Word document.
They are created in Word. Is that correct?
Yes, that is correct.
Okay.
And in EOT, when we talk about the website on Monday or start to, we'll also talk about what format the minutes should be on the website, whether it's Word, PDF, searchable PDF, et cetera. So we'll get to that.
That is an issue that would need to be brought up with the IT department.
Which is what we're going to talk about Monday. So yes, we're figuring all this out.
Okay.
And we want to make it work. We
Make
may
it
have to
easy
tweak
for
this
you.
further when we go to 2 meetings a month in terms of keeping up. I mean, doing this right takes time. Doing this takes time. Doing this right takes more time.
Yeah.
But I think we want to do this right.
But I would definitely leave it to Mr. Young to what works for you, as long as we can get the information, but what works for you. So you tell us. But that's kind of the way. Okay.
We will create a process and document it.
Perfect. Okay. Let's go to the, so, well, no one, did you make a motion about continuing
Yes,
it?
the motion has been made.
Oh, okay,
Continue.
and it was seconded?
Yes.
Second, okay. So is there public comment on this issue?
Peter Warfield, Library Users Association. I'm glad you want to get the minutes right. And so I certainly support the motion that has been made. What I would like for the assistance of the public, first of all, is we have here a new, looks like what used to be called task force administrator. It's not clear to me when you say you're going to do this and you did that. I don't know when Mr. Young came, how long he's going to stay. I think it would be useful, if it's even ever been mentioned, for you to explain for everybody's benefit what the term, is this a one-time, 1 year, 10-year assignment, or what's the deal? The other concern that I have is that I am concerned about the non-publicness of the process. I think it's very useful for yourselves and the public to know what everybody is thinking and what their concerns are, as well as what their expectations are. And whether you want perhaps to discuss that's too much detail, too little, it's an unreasonable or a reasonable expectation, and for the public to be a part of it. I'm getting the sense, it's not clear to me your mechanisms, but it sounds like everybody is going to be sending their ideas to the administrator. Well, what happens if there are overlapping or conflicting requests for changes? How are those going to be mediated, if you like, or straightened out by the administrator? If you have, unfortunately, democracy is time-consuming, and it's not the most efficient thing, but of course the most efficient thing would be to shoot everybody and just do whatever the dictator wants. But I think it would be helpful and useful to have some kind of public nature for what people are requesting, whether it's everybody making whatever version of minutes they want and so on and so forth, whether it's through a discussion. The other thing is change tracking and change marking. When somebody looks at minutes, what's changed? Do I want to look at a 7-page document where only a grammatical correction was made on page 6 and a vote correction was made on page 2, and maybe somebody on page 3 thought that there ought to be a little more clarity or discussion? There needs to be a mechanism, and technical writers will tell you how to do it, to mark for the benefit of yourselves and the public where the changes were made and hopefully what they were, but certainly where changes were made. So it's not a definitive comment about how to do things, but those are some objectives, I think, that are worthwhile. Thank you.
And just to answer your question, Mr. Young is the new task force administrator and has been with us for, this is your second meeting, for the second round, and he is here for the foreseeable future. You're welcome. Is there any more public comment on this issue? If not, I'm going to close public comment. And Member Nee?
Yes. Mr. Young indicated that on grammatical issues, he would make the decision. Respectfully, I disagree. Minutes belong to the task force and the public, not to the administrator.
So on that point, I think what I'm suggesting is that we leave it to Victor's discretion to take various comments from whoever, and when the latest and greatest version goes out in the packet, if we don't like it, we can make changes at the meeting, and it's actually the version that we adopt at the meeting, either as presented or as marked up or however we do it. Those are the final minutes. We make the final decision on the minutes. So I think it's going to be a combination, and we'll work through it. If something doesn't work, we'll tweak it further.
Thank you.
Exactly. Okay, can we take a vote on the motion?
Can we do it without objection?
Yeah, actually we could. I believe so. I'd like to move that the motion's been passed without objection. Can we go to the next item on the agenda?
Item number 19, Administrator's Report.
I have some comments and questions. But
Why don't you let Mr. Young, if you could present what you would like to present in your report?
I'm not exactly sure what I should be reading off my report. However,
I think the most important thing...
Your chance
It's your chance to shine. Why don't you tell us how many complaints you've mediated, and then most importantly, we are trying to implement about the additional meetings, and that's really important, about the time, the days that are available, the calendar, so we can figure that out. And then that's pretty much the most important
this
thing.
month there were 4 new complaints filed. One item was mediated. The complainant still wishes to go forward. There are 3 other items that are still in process. We have not received a response back from the respondent at this time.
Okay.
Currently, we have approximately 44 complaints filed, plus I did receive another 4 today.
Okay, great. Can you speak more?
44, did you say?
Wow.
We have 44 active complaints with another 4 submitted today.
Okay.
Concerning meeting room availability, that is on the second page of my report. It's on the back. I have listed dates that are tentatively available. I do need to confirm this with the building manager.
So you guys, yeah, this is important. So we can't, our January meeting, we won't have a January because it's on New Year's Day, so we won't have that meeting. So we need to change that meeting. The only day that meeting rooms are available for the month of January are January 28th and 30th. So we want to, so we can decide right now which day you guys want to choose for that, knowing that probably then are trying to do the 2 meetings per month won't start until February because that's when the rooms start to be available again.
January 8th is not available.
28th.
28th.
It's not available.
No, it's not.
The only availability is what's
These
on
are
this
the
piece of paper.
availabilities.
Yeah.
So we would go from tonight until either the 28th or the 30th without a meeting of all 9 of us in the same room?
I miss you terribly.
So then we'd have to do our 2, and we said we were going to start doing 2 meetings.
I know, but...
So we need to think it through how we want to do that, because then in February, because we would have met January 28th, we could either do that as a special meeting and then just hear a bunch of complaints and then go to our regular February 5th meeting, which is available. We could do that. But then, do we do that and then do another meeting the 25th? Or it just depends how people's schedules work. So
Let's start with January.
let's just start, because the rooms will get booked up. So that's why it's important for us to try to figure it out.
Grant, do we need motions or do we just raise our hands?
No, let's just talk. Remember, Nee.
Well, yeah, I think there may be a little bit of a legal problem here because there is nothing on our agenda tonight for deciding on future meeting dates. So we could be getting ourselves in, particularly with the January meeting, we could be getting ourselves in a little bit of hot water.
Didn't we bring this up in last month's meeting? And that was what Victor was going to go. And we asked him to go back, and he was going to see the dates that were available, if I'm not mistaken.
I think to be careful about this legally, I think what we're doing is expressing our availability, giving that to the chair, and the chair has discretion to set special meetings and to cancel regular meetings based on quorum and availability, and that's all we're doing. We're not taking action on this, we're just expressing our availability.
Yeah, so the
Does that
January
make you feel
meeting.
a little better?
Yeah, because I don't
Yeah,
know what people can, we can't
I think if
even,
we make a decision, if we take a vote tonight, I think we could be getting ourselves in a little bit of trouble.
what's today, December, but we need to decide, I don't even know if quorums will be available these days, so that's kind of where I'm trying to see if these days were even
We can just
available.
do show of hands for both dates.
I believe January 28th is a Tuesday, January 30th is a Thursday.
Okay, so for the majority, I mean, what are you guys thinking? Tuesday better, Thursday?
Tuesday.
Okay, wait.
One half doesn't
Thursday?
be good for me.
Just start with Tuesday.
Tuesday?
Tuesday, raise your hand.
January 28th, who could be at that meeting? 2, 3, 4, 5, 6, 7. Okay, and then Thursday?
Oh, we can vote twice?
Oh, okay, I could be there too.
Are you asking if we can be there or if we can?
You can be at the meeting.
Oh, if we can be at the meeting.
Yeah, if you can be at the meeting.
Pick one or the other.
No, I just need to know how many people, who could be at the Thursday, the 30th meeting? Put your hands up. 1, 2, 3, 4, 5,
Tuesday.
6, 7. And you can't be at the 30th, okay? And you can't either. So it's even. So,
Could I just make a comment about
Yeah.
Tuesday meetings is the same day that the Board of Supervisors meets. And so,
Okay.
just like for the public,
okay.
that's kind of, to me, that's kind of a conflict of offering a meeting on a Tuesday night.
But I think on a special exception,
When they're meeting, there are occasional Tuesdays like yesterday when they weren't, but yes, as a general rule, we should try not to where we can.
So maybe for the first one, we could go for the 30th then? Because, yeah, let's just put that down for the first one. Okay, then February 12th, now we would have, so what are you guys thinking? The February normal meeting is, we could still do that, February 5th.
yeah, we should.
So we should just do that.
So
And we could, now, do you want to make the January 30th meeting, I can make that a special meeting, and it could be just the complaints. So we could just hear those complaints there, and then go back to our regular meeting. So we won't have a regular meeting in January, and we'll come back to that in February. Is that good? So we'll keep our regular meeting February 5th. And then for our second meeting, to give space, can we do it on the 25th? To create that second special meeting?
Skip over the 12th and the 17th entirely.
We're only doing 2 meetings per month, so yeah, because if you have a meeting on the 5th, it's too much to ask people to come the 12th, the 7th, or the 17th.
Again, the 25th would be a Tuesday. And we might be bumping up against the Board of Supervisors if
I think you meant the 26th, right?
No,
They're all, you've got-
February 25th.
You've got Wednesday the 12th, you've got Wednesday the 12th, the 17th is a Monday.
But that's going to be a holiday, so that means the board won't meet on February 18th, but they are meeting on February 25th. Victor, does that sound right?
I do not have holidays in my calendar at this moment, but
But just thinking, they normally don't meet the day after a
they
holiday,
normally do not meet after a holiday.
which means it's less likely that they'll meet on the 18th, more likely that they will meet on the 25th. So if we meet on the 25th, we'd be running up against a board meeting at the same time.
Okay, so the only other day would be the 17th, which is a Monday.
That's
Is it a holiday?
Oh, that's a holiday.
My apologies, I don't have a calendar with holidays
okay.
on it.
That's the holiday.
Okay, so we can't do that.
Everybody cross that out.
So do you guys want to take that time, the 25th? We might as well. Yeah, because that will give us our second date. With a show of hands, will the majority of people be available for that?
Yes.
Okay, cool, okay. Okay, so then, let's just go to March, I think that'll, or, I don't know, Victor. Okay, so March 3rd is our regular meeting, right?
March 5th is the regular meeting date.
Okay, so we don't want March 3rd, so, okay, so we have the 5th, yeah. And then, what's the 25th and 26th?
The 25th is a Tuesday.
So how about the
26th?
26th,
The 26th.
that Wednesday? What is our compliance?
It's the second Tuesday.
Tuesday, okay.
No, it's the third Tuesday.
It's the third.
Oh, it is the
Yeah.
third Tuesday.
And when is yours?
Second
Usually?
Monday.
Okay, Mondays, okay. So then for April,
April 2nd is the first Wednesday of the month.
what's the date of that?
April 2nd.
Oh, April 2nd, okay, so we'll have a meeting April 2nd, so we won't be meeting April 7th. So why don't we just do the same thing and just do it April 29th or 30th, towards into, so the 30th, which is a Wednesday. Okay.
So in some cases, these are back-to-back Wednesdays, or consecutive Wednesdays. So April 30th would then get us to May, what is it, 5th, if we go to May? Yeah. So
We won't be doing this.
We're just figuring this out until we figure this out. I mean.
Yeah, but right now, we're going to just do April 3rd, and then, because that is a lot. Or is it better, is that okay for you guys, or do you want to do it more that, like, April 3rd, and then do the 22nd? Is that better? Because then you don't feel like...
No, because we have compliance probably that week.
So we're for sure...
No, you have compliance on the 15th of April.
Oh, okay.
Are we still deciding the 2nd April?
Yes.
So we've got the 2nd.
So I put the 30th, just because I was like, let's just spread it out that way.
But then we go into
But
May.
then it bunches up against the
First meeting, so it's up to you guys how you want to do it. I mean...
The problem is the 29th and the 22nd are both Tuesdays. That's your Tuesday factor.
Okay, so let's just, I'm going to say,
30th?
let's just, yeah. That means, because they're two different kinds of meetings. So we're going to just be very directed for the, okay. Then we have May 3rd, and then we could do,
May 7th is the first Wednesday of the month.
so that's our regular meeting, and then we could do 2 weeks later, the 19th, to change it up?
Hold on.
Are we done by now? I mean, do we
Yeah,
really
our
need
terms end on April 27th, so why don't we cut it there for the
Perfect.
moment, and then we'll see where we're at?
Maybe we should keep going and just reserve the rooms.
All right.
I just want to reserve the
Yeah, no,
rooms.
that's good for room reservation,
Cool,
but
so
bearing
then
it all
in
in
that
mind.
case, May 7th, and then May 27th, then whatever the June regular meeting is, and then June 24th.
Well, our regular meeting is May 7th. Those of us that may or may not be here.
Yes, I just wish to have the rooms reserved so we
Yeah, so
can
you
have
have them.
All right, that's cool, that's
Good
cool.
going.
I feel like I'm jinxing it by putting it in
keep
my
going.
calendar.
So then
May
the
7th. You'll
May
get a recap.
7th, and then we're going to do the 27th, and then for June, whatever the regular day is, and then the 24th. We'll just
I
take
will
that
put
last
in the
one.
request for room reservations, and
See.
I will let you know if it is available and if we have the reservation.
Okay, cool.
Yeah, we did.
You did it.
27th. Bearing in mind the 27th, oh, actually, and the 27th is the day after Memorial Day, so there won't be a board meeting that day. There we go.
Oh, okay, people aren't going to want to do a special meeting the day after Memorial Day.
Well,
So,
you're sure?
I'm pretty sure. I can, so,
So then we're back
people will be traveling.
What was the second date in April?
I would go to the 19th. So do May 19th? Cool. Now, let me ask you, so,
I might have a conflict then.
okay. As long as we have as long as we have a quorum. So for the January meeting, since we're not supposed to be voting on this, how are we going to, because this is December now, so
I have a suggestion.
for our next meeting, how are we going to
I would suggest
determine
that we put out a cancellation notice for the January
The regular meeting
1st,
first.
that you call a special meeting for January 30th, and that's fine. And at the February 5th regular meeting, we put on as an agenda item adopting a regular meeting schedule for the balance of 2014 as an action. Then that will make for a regular schedule, and then they don't have to be noticed as specials because that'll be the new regular.
Perfect.
Even notwithstanding the bylaws, we can still set a regular meeting schedule and amend that, and to the extent that we do that, that's the new regular.
I would recommend just listing special meetings as they occur. Just keep listing them.
Either way.
Because you're going to have to keep
Celia,
extending all
would you
this.
do this? Can you stay with us, or what's
We'll see.
I mean, we sort of forgot one of the most important.
Asked her. The straight complaints.
I don't see a problem with it, but I'll talk to my office.
Okay.
So they know.
And let us know.
Okay, what was the second date in April?
30th.
So this list will be back before us for action.
January,
Yeah.
okay.
Or February, maybe, whatever.
February 30th, I thought.
Oh, yeah, that's a special
Well,
meeting,
let's be clear.
so February.
For the January meeting, we're just going to do complaints, and
Yes.
maybe like 6, 7, 8 of them, like, that are ripe and ready?
Yeah, just doing,
And
yeah.
we picked 30
Okay.
for sure, right? Just making sure of that.
Yes.
Can I go over the list so I make sure I have my dates
Yes.
right?
Good idea.
Okay. So January 30th, will be
Special meeting.
a special meeting in place
Complaints.
of... Just for complaints?
Mhm.
Okay. So you'll have the regular February meeting on the 5th,
Mhm.
5th, special meeting on Tuesday, February 25th, regular meeting on March 5th, special meeting on March 26th, regular meeting April 2nd, special meeting April 30th, regular meeting May 7th, special meeting May 19th, regular meeting June 4th, and then special June 24th.
June 24th, perfect.
I got lost in March. Can you go back to March?
Regular meeting March 5th, special meeting March 26th.
Perfect. Okay.
Some other stuff when we're done with scheduling? But this was
We're
great.
done with this.
This was totally cool.
Okay, so good. So, do you have anything else, Victor?
That completes my report.
Okay, thank you. Okay, so, we'll keep it brief and keep it so we can get
So
going.
on the administrator's report, I think I had asked before about orders of determination. Can we just put in a bullet point about orders of determination that were issued within the last month and any that haven't been issued that are still pending?
Got it.
Not to, whatever time it takes, but just so that we know what's been moving in determination, Bill. Not a problem?
Is that good? Can you do that? Or is that?
I will try
into
to
it?
and see if it becomes an issue or not.
Okay, so just like a bullet point, that's all. And then as to the complaints in the pipeline, I think that's helpful, but I'm not sure what it means. I'm assuming that that means everything...
That we need to hear.
Well, hold on. It's every complaint that's been made that hasn't been before us, so maybe we need a sub-item within that of complaints that have gone through mediation that are waiting for a task force hearing, because I would assume that this includes things that are still in mediation that may not end up needing a hearing before us. Does that make sense?
No, because he's saying in item number 4, he did mediation of complaints. So I understand what you're saying, but that's what he's in the process of mediating. And then you mentioned that you had 3 more cases or something that...
Here's what I'm saying. So, like the 4, not the 4 complaints that came in today, but the 3 complaints in November here, right? These are, the last status update is that they're in mediation. I would assume that they are in the pipeline, but that they are not in, from my perspective, in the same category as complainant requests hearing TBD, that they're not yet ripe for scheduling. Does that make sense?
Is that...
I will need to review this and
Okay.
Right now you can...
analyze it a little further.
Because I'm trying to figure out how far behind we are and if we have a way to sort of track that month to month. That's all.
Okay.
Okay, so there was that bit. There were 2 other things that were on my mind. The supervisor of records report, we need to hear that sometime, so we should do that soon. And we have not done an annual report for the year and a half that we've been here. We should definitely do that before April when we're up for whatever, and we should think about how we want to create that and tasking out the work and all. I mean, we should write something that says that we've done something for the last year and a half.
Definitely send me can you send me a copy of the annual report from before so I can see?
I will find that old copy and send it to you.
So I can see. Okay. Member Nee?
Couple of things on the annual report. It's always helpful if we get each of the committee chairs to submit something to that.
Oh, okay. That'll be
Just summarizing their activities. Also, it would be helpful, I think, to the task force members and to the public if the administrator's report were included in the information packet.
Do you mean the monthly information packet? The monthly packet that goes to...
Yeah, in our meeting packet.
In our meeting packet?
Yeah, the administrator's report, I would like to see them included in the information packet.
Okay.
It gives us more time to look at it in case we want to ask questions and so forth. And there may be members of the public who would like that opportunity as well.
Okay.
And I'm sorry, we used to also have in here the list of communications received, emails in and out, and I didn't see that in this.
The what?
There was a list of communications received by the office. We've got copies of some documents, but there had been...
But here's item 3. You're saying you want the actual
I
communication?
will speak with the previous administrator
and see what options we have about that.
Yes.
Okay, that's cool.
Great. Is there anything else?
I'm done on 19.
Cool.
Concerning the providing the administrator reports in the packet material,
Wait, say it again?
including the administrator's report as part of the packet material, I do not create this document until the day of the meeting to include all
Items, so they'll give you the most updated things, so.
Yes.
Okay.
So if we do want this included as part of the packet, it will need to be created.
No, because I think, I understand what you're saying, because we want the most up-to-date information, so if we can get it at this meeting, because that would have for the month, I think that might be
Rick,
okay for right now.
Can we keep this as a day of event for the moment?
Because he does it today, so that we have the most up-to-date information.
Can we talk in the future about whether to move it back to a...
Try, yeah, so we can get the
It
most.
would be like a week before.
Well, perhaps we could have something in the information packet and then do, if things come in after that, he can, print them up and give them to us
At the meeting,
as
if he does.
as addenda.
Okay, so let's talk about it, and we can see a way that, try to make this work. Okay. All right. If there's nothing else, can you read the next item on the agenda? What happened to you?
Announcements, comments, questions, and future agenda items. Item number 20.
Are there any? Just one
Just to
brief,
recap,
so we
because
can.
we didn't have committee reports on here.
Uh-huh.
EOT did meet last week, Tuesday the 26th. We heard Clark versus the Arts Commission talked about their log and are inviting them to continue to improve that thing. We heard from Ms. Datesh versus the Arts Commission. And we talked a little bit about 12L, and we're continuing to. That was that meeting. We're meeting next Monday, the 9th, talking about the website of the task force. I'll mention that in a second. More on 12L and the Micah Ringel versus planning, and follow up on the letter to Angela Calvillo. So on 12L, what I'm trying to do is create some advice and a letter of inquiry to departments about 12L and what it means and how to implement it. I think we have the authority to do so. I just wanted the full task force to know that we will likely send a letter of inquiry to all the departments asking for their input. We're not making any final decisions about anything. That would come before the full task force, but we want to ask them what's up with 12L.
Okay.
Because we seem to
Have
be
you done
getting
the
along with
letter
that.
to Angela Calvillo?
That's what we're talking about. It's still in the works.
Okay, you've got to get that letter done.
And on the website, we're going to talk about what's on the task force website and think about how to better present the information. If anyone has views on the website, please bring them to the meeting, talk to me,
EOT?
talk to somebody. Yeah. I assume that we have jurisdiction to make recommendations about the website and that does not need to come before the full task force. We'll use our discretion.
But you will bring it, we would love to see what your recommendations are. So-
Okay, but we can
You don't
still
have
go
to.
implement those in the meantime. We're not going to make drastic anything, just clarifying stuff, seeing what's there, what's not, how it's presented.
Okay.
Fair enough?
Okay,
Thank you.
thank you. And the next item on the agenda?
Item 21, adjournment.
Great.
Without
Can I get a
objection,
motion to adjourn this meeting?
without objection, we're all done.
Is everyone good?
Is there any other business?
Okay, great. I move that we adjourn this meeting. It's moved without objection. Have a great night. Thank you. Thank you.